What is the urgency?
Department proceeding has been initiated against the petitioner while holding the post of additional commissioner in the revisional court. My lord.
What is the urgency? That is merit. Urgency.
Proceeding with now.
Take breathe. Take breathe. Yes.
Lordship's adjournment. Notice was also sufficient. Bail matter, lordship's adjournment. That is
When the matter was?
Matter was
Earlier.
earlier 5/1/2026.
One. The interim arrangement. Give it if it comes to me. But I don't think it will come to me. It will go in the routine way.
Inquiry start कर दीजिए.
Inquiry only. Then
Proceeding has been initiated on that ground, my lord.
it's all right. Inquiry started. What is the great urgency? Least it can Saturday. Saturday. Yes. After that. Yes. Next. Yes. Yes. Next.
Item 101 chatting. 109. First
109.
109.
109.
47 permitted to withdraw.
Yes.
Please, my lord. My lord, this the promotion case.
Why this is at the top?
Mention.
My lord, that day I mentioned that 30th is the retiring day, tomorrow.
Yes.
My lord, here what happened, my lord, though the petitioner was, his promotion was due in the year 2022 because he was earlier posted as senior assistant, my lord. Thereafter, after 4 years, that is in the year 2018, my lord. Then 2022, his promotion was due, my lord. My lord, kindly have a glance to page 26.
Madam, here the counter has been filed, rejoinder has been filed. It is set for final hearing.
My lord, my only grievance is that
you may have any grievance, but it is for final disposal. What is the great urgency that it should be heard?
The urgency is that tomorrow is the retirement day, my
That's
lord.
right, but
I'm covered by this judgment.
Maybe, madam, that is on merit. It is not a regular bench. Unless there is a very pressing urgency. Here the counter has been filed, rejoinder has been filed. It needs to be heard.
My lord,
a bench for assigned for today.
Yes,
how can I take it and hear it like this?
My lord, I'm not on the part of hearing.
What is the interim order you are asking? You tell me.
Yes, my lord. This is a
Where is your application? Interim application.
Interim application, my lord.
Trace interim application.
Trace application, my lord.
How can I hear like no?
My lord, just kindly have a glance to this.
Again, you are going on to merits. Merits means counter, rejoinder, pleadings are complete. It has to be heard. Unless you have a very urgent application that this application is to be heard, I can't hear it. I can't touch it.
The retirement day.
Maybe you knew it.
My lord,
you challenge it, and this treaty is pending since
2025.
March 2025. What is the pressing urgency? You can't wait for 2 days.
My lord,
and you knew when the ritual file you are going to be retiring. Where is the interim application? You could have asked for stay or something of that sort. Interim or nothing.
Because
that cannot be stayed, my lord.
Kindly have a glance to my affidavit, which I have.
I can't hear, madam. It is not a regular bench. I can't hear. The pleadings are complete. It needs to be heard. Right on. In this writ petition, showing the urgency, the matter was mentioned. Therefore, this court directed to hear the matter on argument basis today. However, it is discovered that in this writ petition is pending since March 2025. The pleadings in the case is also completed. The respondent has filed the counter, and the petitioner has also filed rejoinder of the counter. Since pleadings are complete, the matter is ready for hearing. Let the matter be listed before the rest of the bench. Yes. Next. Item 24.
This is the matter. The petitioner is continuing as district child protection officer. I will kindly see the appointment.
20.
district child
This is also mentioned.
protection officer.
Hmm.
My lord, there's appointment under 106 of Juvenile Justice Act.
Hmm.
That 106 says that every state government shall constitute a child protection society for the state and child protection unit for every district consisting of such officers. So
You are agreed by what? This
my lord, that's that my
next
lord kindly
44, page 44. Huh?
I am aggrieved. My appointing authority is collector. Now the place 44, my lord.
Hmm.
That the director OC Orissa State Child Protection Society has written to collector regarding disengagement Srimati Pragati Mahanti, District Child Protection Officer, District Child Protection Unit, Cuttack.
Hmm.
My lord, and all the allegations are vague and general in nature. Furthermore, Ms. Mahanti is delayed in submitting the reports and has not maintained records relating to child welfare cases, mandatory inspection of child care. My lord, I have given point to point reply to his explanation.
That has to be gone into.
My lord, that's I am saying when my appointing authority is the collector and not the director. So collector being dictated by the director of OCPS to remove me. So the appointing authority has not applied his mind independently because exactly that type of explanation has asked for and it was being accepted by
What are the allegations?
allegation, my lord, very general in nature, kindly see, and very punitive also, that I have given every last annexure 6, my lord, kindly see, page 27.
20.
Page 27, annexure 6. This is the recent, 26 to 2026.
Hmm.
You are not properly implementing different child protection laws in the interest. There is nothing like 62.
Is it a permanent post?
No, it is a contractual. That's
Then-
why they're doing
then-
it, my lord. That's why I'm saying.
What right you have?
I have a right, my lord, that's the judgment I have come up with
Show me.
Supreme Court, where it says, where it says.
Contractual appointment, they are not satisfied. They
No,
have
that is to be,
discontinued. What right you have?
opportunity has to be given to me to, my lord, because this
I'll
is,
record that. You give explanation, they'll consider it.
I have given explanation.
Then
So that is the vague thing I am saying.
what right you have to continue in the post? You tell me.
My lord, that's I am saying.
Which can be enforced through
My
the
lord.
writ jurisdiction.
My lord, kindly see, my lord, my appointment.
Hmm.
Annexure 1. That is, that I have appointed.
Moreover, these are a contractual appointment. There can't be a stay on that. If you are entitled, you will be given subsequently. I just issue notice.
My lord, that's a lot.
No, I can't say it. Contractual appointment, how can I say?
I am saying the collector being my appointing authority.
Whatever, I am just issuing notice, let them come.
My lord.
My lord,
Next week, issue notice.
yes,
Written-
no, lordship, my lord.
Yes.
Just for one moment, my lord, kindly
Yes.
see page 28.
28, huh?
Pen 28.
Yes. Hmm.
As to why disciplinary administrative action should not be initiated against you for the aforesaid act within 7 days from the date of issue of this letter. Failing which necessary disciplinary action will be taken against you. And on the next date, my lord, when I have filed all my explanation to the director, although he is not my appointing authority, here they have to remove him. So, my lord, this explanation, they have created a situation where only on basis of explanation being taken contractual, the Honorable Apex Court stated, this is your lots of stigmatic because you are alleging against me everything.
That's the reason I'm issuing notice.
That's why I'm saying your
That's the
lots of,
reasoning I'm.
the collector may apply his mind and
That's the reason I'm issuing notice next week.
but no coercive action.
No.
Because if I have filed a regulation case,
In the regulation case that
that they have said no coercive action.
fifth, you answered.
2 weeks, my lord.
No, fifth. You answered it. Because see, he is continuing.
My lord, my lord.
Fifth, issue notice on the writ petition, lease the matter on fifth, and Mr. Bo accepts notice for on interim application also, interim application. Yes,
But
interim
then,
application will be heard on fifth.
my lord, there is another point only that other party 1 month notice they have to give, but they are now immediately relieving me. That is the term of reference.
Fifth,
Khali, what? My lord, one, this, if possible, my lord, There should be no, they will not allow me to join. They will terminate me.
Contractual appointment can't be stayed, madam.
No, I am not saying stay without due
What
process.
situation, are they going to kill you or what?
Without due process of law. My lord, this is.
That is the reason I am issuing notice.
My lord.
You will have
That
to
may-
restore, you will have to be restored. If
My lord, that,
I'll have to, see, ultimately the Annex 8 has to be quashed.
my lord, that may be, my lord, one that.
No, ultimately the Annex 8 has to be quashed. If
We
it is
will
quashed,
start with my lord.
You are lordship, my lord, that is because of your.
I understood everything.
Your lordship knows everything and this is.
So that is the reason I look into the urgency in
Yes,
sense
yes,
is 8 goes,
Without due process of law.
8 goes, due process has to be followed.
Yes.
Even then you can't be stayed, can't continue. After due process only.
They will say, now High Court has not given.
Therefore, I think this will be.
Recent Supreme Court judgment reiterate the Uma Devi case now.
Because in contractual appointment you can't.
Your lordship understands that, but I am saying that my term of reference says.
I think the best thing I have given is 5th.
My lord.
There is
My-
no clear.
My lord, I may be permitted to make a mention.
In between.
Well, what has happened is that they are the in 2015, my lord, I
Well,
advertised-
which one you are talking about?
my lord of Justice Satpathy, Justice Satpathy's assignment, my lord.
Monday.
No, my lord, Monday is the interview, which is divorce of the judgment of this court and also found by Supreme Court.
What evidence?
My lord, what has happened in 2015, there was a advertisement pursuant to the Works Department, Assistant Executive Engineer.
The process has already been started.
No, no.
Who are you?
I am a successful candidate, man.
No.
I have been employed for last 10 years.
Saturday.
Saturday.
Yes.
Friday as
Saturday, sir. Friday will be.
okay, Saturday.
Yes. Yes.
Item 1.
One minute. On behalf of the Vigilance Council, one possible. He's on the way, that's it.
Item 2.
Possible, my lord. Sir, my senior is not available, my lord. I'm busy.
Adjourn.
Adjourn.
Item 3.
Yes.
It's regarding correction of.
Date of birth. High school certificate. Issue notice, huh? Issue notice.
It's a correction of date of birth, 1966 to.
No, some benefit can be given to that.
It's a
who-
Miller's,
who
it's a
is he?
disputed question of fact, suit is maintainable.
I know, Ramesh comes from Pittsburgh. Oh,
Yes,
he's,
your lordship.
he's now 58 years.
Yes.
What will he do? Acha, he must be working somewhere.
At
Therefore, you want to
at the
about
fag end of the career is as per the.
pass out. Let us see, pass out.
4.
The petitioner has
He's
applied-
working, sorry, he's working where? This man? Director of Secondary Education.
Yes.
Okay, pass out. Yes, next. 4.
Item 4.
Madam, the petitioner was one of the applicant for the post of master bookkeeper MBK. And the office petitioner 7 has been illegally selected by the selection committee. And by challenging that, I had filed a writ application, WPC number 6047 of 2025. And that case was disposed of. Your lordship may kindly see the
Yes.
order.
Hmm.
On the annex of 7 at page 39.
Yes.
The ordering portion is that at page 41.
Yes.
42. Since the plea of the petitioner is primarily the inaction of the authorities, para 8 member. In entertaining the grievance of the petitioner, it is directed that in the event the petitioner makes a fresh representation along with a copy of this order and a copy of this writ petition within a period of 2 weeks, the supplement of Nabarangpur shall dispose of the same by passing a rigid order within a period of 4 weeks from the date of receipt production of copy of this order along with copy of writ petition. Thereafter,
Thereafter it is rejected now.
no, not rejected. That on my representation, an order was passed by the sub-collector. Your lordship may kindly see annex of 7 as page 54.
Yes.
that the sub-collector admitted the case of the present petition.
Hmm.
And
Hmm.
at conclusion, at running page at
Yes, read it, read it, read it.
56.
Read it.
56, conclusion. Although the BLF, Paprahandi and GPLF of Nuwapati GP have engaged Srimati Ranjita Manjari Biswai, the office partner said that Village Pitrikuda as MDK in Nuwapati GP for a period of 12 months, but no resolution has been made by the committee, and the fact has also been intimated by the President of BLF Paprahandi Block. As per the guideline of State Mission Director Orissa Livelihood Mission, Department of Missions of the Government of Orissa issued by letter number so and so addressed to all collectors, BPC and BPM shall attend the selection committee meeting, will oversee the entire process and shall submit a joint report to BDO and CDO. They shall ensure that the entire selection process is free and fair. In case if any prima facie fraudulent activity is noticed during selection process, that shall be brought to the notice of the concerned BDO. But the time of selection, the post of BPM in Paprahandi block was vacant and Pritikanta Sahu was working as a BPC in ICDS project Paprahandi block. Now working as BPM in ICDS project Umarkot was responsible for all selection process for the post of MDK in Nuwapati GP. He has not maintained all records proceedings as per the guidelines.
What is ultimately what is said?
That
Considering the overhead, the block development
on
program,
perusal of
development
the third para
are
third.
directed to
On perusal
review
documents
the
produced
selection.
as
Review the selection process.
Madam,
They say is review the selection process.
review the selection process.
Then
I am the opinion that the selection committee has maintained the relevant records of the selection process.
everything is recorded. Thereafter, he says
And
review.
thereafter he sent the record to the BDO and the CDPO for
Yes.
inquiry.
Hmm.
And BDO and CDPO has made their inquiry report,
Hmm.
which is as page 59, annexure 10.
Yes.
The BDO and the CDPO in their inquiry report as well. Towards last, the resolution of the GPLF for requisition of MBK and Nuwapati GP was not prepared at the same time. Indent was not given to the BLF, and the same has not been produced during the inquiry. BLF resolution was not made regarding the selection of MBK.
So then they say that selection process is
The
complete.
selection process is void.
Wait, yes.
And I am the petitioner. I should have been selected for the post that
So the a fresh selection will be done. You
fair
participate.
selection mark
Participate. If it is entire, it is if the selection process is found to be
Your
tainted.
lordship will kindly see page 60.
You say that it's tainted
No,
and it is found to be tainted.
the
Select cancel. What
the
to do?
existing MBK is still continuing. Though the order of
But see, you came to this court, obtained that order. Thereafter, the
selection
concerned
process
authority
happened.
found it, the entire process was tainted.
Subclub has said in his order that
Don't read one line somewhere, but they,
re-evaluate the marks. Re-evaluate the marks.
see, all these things are disputed facts. And moreover, after inquiry, it was found that the entire process was bad. So
Void.
therefore, void. Therefore, it goes. A fresh process will be taken place. You participate. What to do? You have invited that.
Now that has not been done since last.
That is a different again grievance. That's a
Yeah,
different.
nine
They have
months.
not
Very
done.
not
They
a
have
fair-
done
very
25
different.
And it's
October
still
20.
continuing. Since last 9 months, though the selection is declared as void.
Your grievance is that she is continuing despite the selection declared void. That is the grievance.
I should have selected for the post.
You
because I
should have
secured-
selected is something
I
different.
had secured, the report was submitted to subcollector, subcollector has not taken action.
I don't think.
Report is submitted by the video and CDPO
Yes.
to the subcollector, subcollector is the final authority.
Then I can only direct that they should process for
To
the
the
fresh selection.
Now, for the subcollector to
Press
take a
it.
decision on the inquiry report of the video and
Fresh selection.
their selection, but move select हवा करता move higher mark रखी.
Man, pursuant to the direction of the sub-collector, BDO has been taken action.
And they
And
have
it is found to be
they have
tainted.
taken the subcollector has to take decision on the
Simple issue notice. It will be pending nothing. You are not going to get anything. Rather, I should dispose it of saying that since it was found that the selection process is bad, let there be a fresh selection process. You will participate there. That is the best solution at this time. Otherwise, she will continue.
Notice like क्या हुआ?
I'll issue notice, counter, rejoinder, and all these things. He will continue for 5-6 years. Thereafter, she will say that I have been continuing. So the court will take a lenient view and everything is dropped. At least you have a chance that also will go.
Disposal is better
Shall I
than
dispose it up?
purchase.
Directing them to take fresh steps for fresh selection? Then I'll issue notice because in any case, she is already selected working. Behind her back, why should I pass the order? Issue notice. Short notice, 21st. Take out the notice, so and so accept notice for the year and for 7, huh? Take out the notice for 7. 7 and who is 8? Who is 8?
7 and 8.
7 and 8. 2 posts, huh? 2 posts. Since they are already.
One post. One post.
Who is then Pinky?
Last selection plus the second one, third.
Okay, they accrued some right. They have to be heard. Issue notice. So and so accepts notice for 1 to 6 and for 7 and 8 within 2 working days processes to be filed. Yes. Next.
Item 5.
Return.
21st. Yes, before vacation. Yes, ma'am.
Correction of, if petitioner seeking for correction of
Correction
matriculation
of-
certificate.
Which one?
Item 5.
Correction of judgment.
No. Matriculation certificate. Name of the
Matriculation certificate
Yeah, decree has been plus
is 25 years.
it has been decreed in their favor that declare that I am the natural son of such and such.
I'll issue notice if there
Thereafter, he has sought for the correction of the matric.
issue notice, huh? Issue notice. Written notice immediately after. Yes, next.
Item 6. May I please? Here in this case, correction of date of birth. My date of birth is 24/10/2006. Instead of that, it has been wrongly mentioned as 4/24 jagara 4 ages.
Look, issue notice. Issue notice. Let us issue
Right.
notice. Yes. Next. 7.
Item 7.
Lord, in this case, petitioner prayed for correction of her mother's name, my lord. That has been inadvertently Rukia Bibi instead of Rukia Bibi, my lord. Earlier,
Name where? Correction of name in the
name in a board certificate, my lord.
that is absolutely
CBSE is the penalty.
petition is seeking the correction of the name of his mother or her mother. Her
Board,
mother
Board.
in the board certificate. Board certificate and invoke the rejurisdiction, issue notice, written motion. Yes. Next.
Item 8.
I got mention there for us. 8.
In the case, mother may kindly be changed.
Huh?
A board certificate.
Same board certificate.
The CBSE.
Mother's name.
I,
Mother's name. Change of mother's name and board certificate issue notice. Yes. Yes.
Item 9.
May it please, your lordships. I'm a private unaided school. It's under the RTE Act. I have a claim of 25% of reimbursement towards the reserved category children. It means for all last 3 years, I had made those claims. And because of their inaction, I had approached your lordships in one of the writ petitions. That is at page 34.
Page 30.
Page 34, my lords.
Yes. Yes.
So your lordships are directed for consideration of my representation. And post the consideration minutes at page 37, they had passed an order allowing my claim of reimbursement for 2019-20, 21-22, and 22-23. So this is pertaining to the claim for 24-25. Now again, I had given them the reimbursement sheet, but they have not acted upon it. They said that there is some kind of discrepancy at page 40.
Cure the discrepancy.
I had cured
Every year you can't file, keep on filing it.
I had submitted back to them. I submitted to them, but no action is taken at their end.
Every time you can't, expect that writ court should keep on giving direction and you get the money.
Because what I'm trying to visit your lordship, so the guideline says, suppose this is the academic year, so I have to make my claim the next year. So for last 3 years and 4 years, it was pending.
What is the objection, Sumi?
So I had given my objection at page 41. 41, Annexure 7.
Yes.
Page 41.
Where are the objections?
There was on page 42.
Ah.
Page 42. तारीख 29/11/25 लेटर नंबर 2164 रे हमको कहउछन जे तुम विद्यालय कागज पत्र मिसमैच होउची.
This is your letterhead.
Yes, sir.
Show me their objection.
Their objection is at page 40.
40.
Well,
Yes. With reference to subject.
there are significant mismatches in the data submitted with respect to fee structure, admission and readmission details, guardian statement and entries
There
in
are
the collection fees register. In this context,
significant mismatches.
Yes.
In the data submitted by you.
data submitted.
So we'll correct it here, sitting in
No,
the
look,
court.
I have given.
Correct it.
I have given that to them, but they have not taken any action.
They'll take it. They'll take.
Looks at,
When have you given it?
looks at page 41. The next annex.
What is the amount?
Plus the amount is rupees 21,400 for each of the children.
So how much total comes?
The total would come to that's 1,60,780.
Well, that's the whole difficulty. Every academic year you keep on coming. These are administrative work. You want a read court to decide all these things.
Let them take an action on it.
See, the same thing happen. Every time you come, representation and court indulgence. Why indulgence? What right you have?
I'm claiming
Why?
that item.
See, these are administrative work. You have given some bill, they objected to it, you cure the defect, they'll do it.
Plus the guideline says.
Well, what read court says, read court job is there.
Plus the guideline at page 19. Page 19 is
You
the
impress them. See, this is the, for 1 lakh rupees you come every year you are coming.
If they're not able to have
Every year coming. Where is the decline? Show me.
They have not declined it.
Then wait
Not
till
yet
decline.
declined.
Then the cause of action arose.
Because last.
Then if once they decline, then cause of action arose.
But the page 19, the guideline says, after admission of children.
Let them apply their mind, they decline it, then you come. Have they said that they will not pay you?
You are the defectant.
Have they said?
Last time they didn't do so. That's why-
Last time they didn't, so therefore.
And now if they don't do so,
Yeah,
I'm
no,
not
no.
able to handle the school.
Wait, it is premature. It is
I have
premature.
to handle the school.
Madam, petitioner by invoking writ jurisdiction of this court has prayed, has made following prayers. The grievance of the petitioner is the reimbursement, the entitled reimbursement for the year 40 calendar, entitled reimbursed for the academic year 24-25 has not been paid to the institution. Rather, despite complying the every requirement as per the guidelines, he has counsel for the petitioner pointed out the letter dated 29/11/2025, whereby the video office of video has pointed out certain defects, certain defects in the proposal. Reimbursement proposal submitted by the institution. The council submits that on 3/12/2025, the defects pointed out by the office of video has already been cured. Still, the reimbursement proposal has not been processed and the payment has not yet been made. But nothing has been placed on record to show that the reimbursement has been declined by the competent authority. Since not declined by the competent, since there is no specific order passed by the competent authority declining to reimburse the proposal, entitled reimbursement for 25-26. No cause of action as such has accrued in favor of the petitioner to maintain the present petition. Hence, I am not inclined to entertain this petition of this case. Yes. Next.
Let them consider that annexure 8 if it's.
This is what we are committing mistakes. And you have converted this High Court to a BDO office.
Last time when I been before Lordship.
It is the writ courts are now converted to BDO office or executive engineer.
Section 12 of the.
Every time where is the cause of action? You tell me.
Section.
You apprehend that they may not do. Therefore, you come.
They have not done for last 3 years, in 3 academic sessions.
I have said that they have cause of action not accrued. Once they reject, you come. Yes.
Item 10.
Yes.
May.
Yes.
And the improvement letter is at annexure 5. Forfeiture of the 28% of the pledging money of the college, my lord.
Forfeiture of 25%?
Of the pledging money, my lord. Fact of the case like this, my lord, by the annexure 1, my lord, if lordship will see.
No, this forfeiture, pledging money of what?
Pledging money, my lord, for running the institution, director, my lord, by the annexure 1 while granting permission to the college, my lord. In the 2018, 2018, that is when, my lord, I draw your lordship's kind attention to annexure 1. Permission to open the college, my lord, it was given on 18/6/2018. Paragraph 1 stated the financial applications. They have stated that, my lord, for +3 opening of the +3 degree college self-financing college, my lord, you have to deposit 30 lakhs, my lord, in 2 installments for a period of 10 years. My lord, then, my lord, but annexure 2, my lord, temporary recognition was given during that COVID time, my lord, in the year 2022, my lord. So, my lord, after that, my lord, students were admitted. And my lord, they have stated that for the next 2 years that 15 lakhs rupees is necessary. That is why deposit. He made an application that due to the recession, my lord, due to the COVID, my lord.
You are agreed by what? Which?
I am agreed by, my lord, forfeiture because in the meantime, my lord, they have closed the college for non-deposit of the second installment.
Where is the forfeiture order?
My lord, annexure 5, my lord.
Annexure?
Annexure 5.
Yes.
At page 19, my lord. The deposit of the college, my lord, for a period of 10 years. Now, my lord, for revival of the college, my lord, they have made application and it was closed, my lord. And 15 lakhs have been deposited. The condition, my lord, is silent about that forfeiture. They have stated that, my lord, the amount will be deposited for a period of 10 years.
Issue notice.
Your lordship, see the annex of C.
Annexure?
Annex 3, page 17.
7?
17.
No, that I have shown that.
3, yes?
Set a decline.
17, yes.
With reference to.
My lord, then, my lord, then, my lord, I am showing the.
Withdrawal of recognition of so township.
And he has decided for withdrawal of
Non-fulfillment of the condition regarding this.
non-fulfillment of condition regarding deposit of second installment.
That is why, my lord, I have made an application, my lord, that I have stated for lordship that the, my lord.
That's why recovery. Annex.
No,
Why,
recovery
you,
part,
admittedly you have not deposited.
recovery part was not there, my lord.
No. Show me the.
My lord, your lordship, that is why I showed your lordship, my lord, annexure 1.
Annexure 1, very
Yes.
just provision.
Annexure 1, my lord, that is the permission
Forfeit.
and the financial condition. Your lordship,
Yes.
kindly, my portion is, your lordship, kindly come to the 9th line, my lord. 9th line, paragraph 1, my lord.
Clause 1.
Clause 1.
Yes.
Starts with similarly, the education agency sponsoring self-financing degree college in KBK scheduled areas, other areas shall place an amount of rupees 15 lakhs, only 30 lakhs in favor of the prescribed authority for a period of 10 years. And so rupees 75 lakhs in favor of bank deposit in current account of the prescribed authority, my lords. That is, my lord, that amount should be deposited there for a period of 10 years. That is the only condition, my lord.
No, but if you don't comply with the further conditions.
My lord, now, my lord, what happened, my lord? I am trying to revive, my lord,
You revive then.
My lord, if at all, my lord, if at all forfeiture will be made, my lord, the entire process will go.
No, that is a different, you have, where you said that you are going to revive.
My lord, your lordship, can see annexure, my lord, I have, my lord, taken over.
Forfeiture clause, show me.
Forfeiture clause is not there, my lord. That is my, my lord, line of. Your lordship, annexure 1, my lord, that financial obligations, my lord. In the forfeiture clause, my lord, they are saying that annexure 5, there is a notification. In the year 2014, annexure 5, people lordship will see.
All conditions. Where is the forfeiture clause?
Forfeiture clause is not there, my lord. That I want to draw your lordship's kind attention.
Yes. Where is there any
That
forfeiture
was,
clause?
yes. If at all forfeiture clause was there, my lord, I don't have any grievance, my lord. I know, my lord, that is the terms and condition of the permission.
Just see, the above permission is subject to fulfillment of the following terms and conditions. In the terms and conditions, there is no forfeiture clause. Just see, is there any forfeiture clause? Terms are there.
Nothing is there, my lord.
All conditions prescribed within terms of rule made thereunder should be fulfilled. Not recognized enough pressure number of necessary issue notice. Yes. Next.
My lord, I have filed a miscase, my lord, not to take any coercive action.
No, you have said this.
My lord, if the forfeiture will be done, my lord, that application will be infructuous.
No, nothing.
Because they have already.
You will get back your money. If
No, my
you
lord,
can't forbid, then
I am not, my lord, I am not on that, my lord. My lord, my predicament here, my lord. if the forfeiture will be made, my lord, the fate of the college will be closed for all times.
No, that is necessary.
Because that
Is
is.
notice on the application. Is noticing the application.
My lord, your lordship,
You have to see the rules, corresponding rules also. They are not able to access. Therefore, I am giving notice. Otherwise, if you will go into it, you may lose it. Lose the case. If you want, then I'll keep it for hearing in Saturday.
Because there is no rule.
I know
right now.
there are corresponding rules. You are not, neither you are pointing out, nor he is.
My lord, I am pointing out.
Annex that rule.
So therefore, you don't get notice. You will be happy.
So on the annex of 3.
If you notice, at least the matter.
No, it's not, my lord and friend says that, my lord, I don't have to.
11th May, yes.
My lord, I have never, my lord, misled this honorable court. I have not shown any document which shows my credibility.
You are a defaulter.
I am a
For
defaulter.
the purpose of default, there must be some.
So my intention was not to conceal anything, my lord. When I have even annexure 3, my lord.
He's not saying that. Okay.
He's saying that, but I have not shown annexure 3 repeatedly, he's saying.
Okay, 11th, next.
My lord, they have shown one.
Next, 11th, okay.
My lord, till then, my lord.
11th May, yes, next.
Item 11.
They have given one notification, my lord. They are saying that as per the notification of 2014, I am
We'll
forfeiting.
see, 11th, yes, that is.
11 minutes, that is the minutes, assignment is that court note 20.
Huh?
It's a SSG group, assignment is court note 21.
How this has come?
I don't know, lordship. Which we mentioned.
It is specifically assigned to the court note 21.
Is it
11
directed
at
to
work.
me? Please the matter before the assigned bench on 5th.
May only lordship add one line, along with written person 9264, because we have given mention, given 2 numbers, lordship. What are connected matters? No. How did I see? Did I consequential action did I?
Along with the connected read.
9264, 9221 and 9264 of 126. Yes, reference.
Yes, next.
12. Bunda cell. Data data cell.
12 also. Now, how these matters directly listed?
It is special bench constituted, lordship.
Huh?
Special bench has been constituted for listing of this matter, lordship. 2 benches here, lordship.
Is there any order for that effect? No, if it is listed specially for this. List on court. If it is to come to this court, let it be. Okay. Court, huh? If the it is eventually it is to come to this court, it will come.
Lordship. Reference.
I'm not saying
Lordship.
assignments, they'll verify them.
Lordship.
11, 12, huh? Verify. Yes.
Item 13.
May I please, lordship? So I may be permitted to submit through VC, lordship.
Yes, yes.
This matter is relating, lordship, petty procurement, lordship. My entry was, lordship, under Annex 1. My total land, lordship, 6 acres, lordship. And I also entry before the data entry operator regarding 6 acres, lordship. My collection of the petty, lordship, 45.
This matter is also, my lord, this assignment bench will matter.
SSG group and paddy.
That is the
Paddy 21.
21. Court number 21.
Monday. Just ask, huh? Monday, if it is to come to this court, no problem. Why it is listed? Special assignment.
No, I have no problem, your lordship.
Yes.
Item 14, you know the petitioner, item 14 to 21, all are similar. The petitioner in the 14 cases, when it is 14 to 21, all are similar. The petitioner were initially appointed as a non-formal instructor under the particular scheme. And after closure of the scheme, he was retrenched. And thereafter, government introduced another scheme, Annex 2, Annex 3, to rehabilitate the ex-NAP.
What are you seeking?
Seeking for re-engagement in view of Annex 9, the recent judgment, page 35. Page 35. The recent judgment passed by the coordinate bench, also Annex 9 2 judgment, Annex 9 series. And thereafter, the government have also directed the director to call for the report. Now the matter is pending.
in the out of similar matter, my lord, last my lord, day before yesterday, already three matter already disposed of by lords. My other court defense. Exactly out of the same batch. To consider my claim as per the above that judgment, my lord.
He was returned from the service
Yes,
from 2001, my lord. Now 2026.
yes.
How can he engage, my lord?
I'm relying on your
You are remaining reliant. But that is not the fact. That is what is the fact in the case, my lord.
fact amount କହିବାକୁ ଦିଅ କହୁଛି
2001 से रिसेंट ହେଇଗଲାଣି କିନ୍ତୁ 2026 ରେ କେମିତି why will he engage?
ଦେଖନ୍ତୁ ତିନି ସ୍କିମ୍ କ୍ଲୋଜ ହେଲା ତିନି ରିଟର୍ନ ଦେଲୁ all the returns
That is
employee ଏ 8 ରେ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ସର୍କୁଲାର ଆଣିଲେ to rehabilitate and thereafter annexure 9 has been passed by the
All right, I'll dispose of. Just see the paragraph 4.
I have gone through that.
See paragraph 4. There is no direction. It
Yes.
says that they are covered by this judgment. If they are covered, you give the benefit.
Yes.
If they are not covered, don't give. That's what is the same line. Yes.
all the up to 21.
Same period in the
Same, all one day.
ಈ line ತಗೊಂಡು.
22.
I please. You'll also kindly come to page 13.
30.
13. Annexure 5. The
Sir,
petitioner was an employee.
20.
Page 35.
20.
Page 35. Sorry. Page 35.
22.
Page 35, annexure 5.
Page 35. Okay. This is judgment.
This is judgment of the civil court.
Hmm.
You'll also come to the page 40, issues.
Yes.
Whether the plaintiff is entitled to get the declaration that the date of birth entered in the annual HS examination certificate of the plaintiff dated so and so is not correct and is 12/6/68, not 66/68 as per the transfer certificate issued by Swans High School. Admission
Not correct.
register.
And it is.
Then you also kindly come to page 44, paragraph.
Who is the plaintiff here?
Yeah, petitioner is the plaintiff. Petitioner is the plaintiff.
Mhm.
Page 44, para
44.
8.
44, huh?
Yes, sir.
Yes.
From the entire evidence available in the record, as well as the document by the annexure 4, exhibit 4 and exhibit 7 clearly indicate the date of birth of the plaintiff mentioned is in this document as 12/6/66. The letter of the headmaster so is marked as exhibit 5. Also revealed that plaintiff has taken the step earlier for correction of the date of birth. These documents are marked by plaintiff PW1 without any objection. If conjoint reading of aforesaid mentioned document as well as the evidence adduced on behalf of the plaintiff give rise to the irresistible conclusion the correct date of birth of plaintiff is 12/6/68. Then
The current date of birth is 12/6/1968.
16, not 66. That is page 46. It is hereby declared, the suit was decreed, it is hereby declared the date of birth entered in the annual HS examination certificate of the plaintiff dated 24/66 is not correct.
Yes, it's all right.
Then you also kindly come. So I had to, because I had approached this honorable court, this honorable court had granted liberty to file a suit. Then after the judgment of the suit, I was directed to file a make a representation. That was rejected. Then that was challenged. Page 50. The
Page
judgment.
50.
Judgment, yes.
Oh, there is a decree. Why don't you execute it?
Sir, kindly come.
I'm agree with your lordship.
Page 50. Page
15. Yes.
This is the judgment of this honorable court.
15.
50, page 51. Let's come to page
51.
51.
Okay.
Let's come to page 52. Para.43. It is contended that by judgment and decree dated 31. Para 4.3. Page 53.
3.
Yes.
Not 3. It is contended
So
that
that it is contended by judgment and decree dated so and so by disposing of the suit and civil judge passed the decree by holding that the date of birth of the petitioner is 12/6/68. It is contended that on the face of such declaration being made by the competent civil court, date of birth of the petitioner was not corrected, and instead the impugned communication was issued by rejecting the petitioner's claim on the ground that no such direction was there by the civil judge to correct the date of birth. Then also kindly come to page 53, 6.1. Let's get it. 6.1. On the face of such request made by the headmaster when the date of birth of the petitioner was not corrected, petitioner approached this court by filing OJC of 2001.
the said writ petition was dismissed for non-prosecution. Writ appeal was filed. Number so and so. This court by order dated 2/11/2021 by setting aside the order dated 29/1/2015. So passed in OJC number so and so, disposed of the writ appeal by granting liberty to the petitioner to approach the civil court for appropriate relief. In terms of such liberty granted by this court in writ appeal number so and so, petitioner moved the Lord Civil Judge Junior Division Cuttack in CS number 228 of.
And that is the decree.
That is the decree.
Yes.
Then also kindly come to last para 6.2 and 6.3. It is in this view of the matter. It is the view of this court that that's 6.2. 6.2. It is the view of this court that on the face of such declaration being made by the competent civil court with opposite party board as the sole defendant, no further direction was required to be issued to the board to make the correction of the date of birth of the petitioner as 12/6/68 in place of 24/66. Since the decree so passed by the civil judge as admitted was never assessed, it has attained the finality in the eye of law. In that view of the matter, the ground on which the petitioner claim has been rejected by the impugned rejection dated 24/2023 by Direction 9 by the opinion number 2 is not sustainable in the eye of law. Therefore, this court is inclined to quash the said rejection. While quashing the same, this court directs the opposite party number 2 to issue a fresh certificate in favor of the petitioner in lieu of annexure 4 by taking the date of birth of the petitioner as 12/6/68. Opinion number 2 is directed to issue a fresh certificate within period of 4 weeks. Now, Your Honor, they did not issue. Now, I have come to Your Honor at page 60, annexure 10.
Yes.
Now, he's going to retire tomorrow. Your Honor, kindly serial number 7. At page 60, serial number 7. And you'll also look to page 62. The order of relief to be, he will be relieved tomorrow. So and so, Director of Industry of Director is hereby relieved.
What is your name?
My name is Nurul Haq. Serial number 7. Serial number 7.
20th April 66 is date of birth.
Right. Then also kindly come to page 62, annexure 11, which is impugned. So and so, Nurul Hussain, Assistant Director of Industries of the Director, is hereby relieved from his duty with effect from 34/2026 on attending the age of.
Yes, what do you say?
Notice.
There is a notice by the time he will be.
He should file and my Lawrence
No.
more experience than myself. My Lawrence Senior, I'm respecting to my Lawrence Senior. He filed an execution proceeding. Start an execution proceeding because the civil court.
There is a direction by this court.
My Lord, I know that. I have gone through that. I've gone through that.
Then contempt was then. What is the order of contempt?
Page 59.
Just see, there is a contempt. Forget about that execution part. Initially, if there would have been decree, I can understand. After decree, they approach this court. There is a direction for correction. Thereafter contempt.
Anyway, my Lord, he should have approached to the civil court for revision. Anyway, my Lord, he approached the honorable court. My prayer that he.
Because
I pray
my initial comment, that is your defense. I commented because I didn't know.
I know. I have gone through the records, my Lord. I have gone through the records.
Sorry,
I agree to you. Notice me.
Read the contempt. Read the contempt.
Notice me, you should, my Lord.
Sir, only the operation of
Board secretary is not party, my Lord. In this case, board secretary is not a party. The council is not present, my Lord. He should have present, my Lord. Board of council present none.
Only your Lordship
Having some say, my Lord.
See, 14/7/2020.
Certificate corruption, board of secondary will correct certificate, my Lord.
1 minute. 14/7/2025, there is a specific order with this court. On the basis of the decree.
My Lord, I am
1 minute. Decree for correction. You didn't do. Thereafter, he filed a contempt. The contempt is disposed of on 24/10/2025, giving you 3 months. You didn't do that. Now tomorrow he is going to retire.
My Lord, I am putting a question to myself, my Lord. Who will correct, my Lord? Why is board of secondary will correct this certificate and issue it to communicate to the government that this is the date of birth.
Who is
board of secondary? The council is not present.
This has already been communicated. That is there.
The council is there, my Lord.
Let me see. Who was the contender?
The contender is the board of secretary.
Board of secondary.
And who were the parties to the first writ petition?
Board. This board has to make the necessary correction. Now only my problem is because of the date of return.
That's the whole difficulty. Now that in the writ petition you have made whom? Board is who is to correct?
Because
Board is
so far the board is concerned.
And in the decree.
Board has submitted the judgment. No, so far both the judgment. Now the question is, the basis of board of certificate is the basis
Just
of.
see, sir, the problem with you is you file a suit without making the government as a party.
My lord.
Sir,
You file the first read without making government as a party.
Sir, I
You
agree.
file a contempt without making government as a party.
Sir, I
Today
agree.
you are seeking relief against the
Sir,
government.
government, now the problem is like this. Suppose the Board of Secondary Education, they suffered the judgment of both this honorable.
And
court.
you knew that you are going to retire.
Sir, I knew, sir, I have made.
You should have come.
Sir, I have already made the application not only before the state.
I can understand. If it is it would have been a judgment in RAM, one
Sir,
can understand.
yeah, declaratory, just for a moment. A suit for declaration that a particular date of birth is not correct. Is it not a declaratory decree? It is not.
Declaratory decree
Sir, it is.
operates in RAM.
Sir, yes.
But when you file the first read petition, you should
Sir,
have made government
in
a party.
the-
Why have you not made?
Sir, in the first writ application, I had to file because the reason is they have to correct it. The certificate is to be corrected.
But government should have been,
Sir, sir.
see, ultimately, benefit, what benefit you wanted? Benefit is service benefit, obviously.
Sir,
For to give service benefit,
obviously,
you have made them party.
I have been approaching right from 2001 itself, sir.
Strategically, you
Sir,
did,
sir,
that's the
sir,
mistake.
sir. But this is my,
Comes now.
sir, this is the problem. I'm going to retire. So what I suggest,
That will
Lord,
not be
can you lordship keep it to next week? Let them take instruction. Let the board
Monday, 4th.
Monday.
Well, board will take instruction.
Not board, you are talking about. See, there is a
Board-
degree. Why are you?
We are not party, my lord. In the suit, we are not party. In the read petition, we are not party, my lord.
Now you didn't see that. I saw it.
I have gone through the record. I am gone through it. Every
The
record.
problem is you don't read.
My lord, because my your lordship has not put a question to me for which I am not giving answer, my lord.
There is a declaration.
My lord.
The suit, it operates in RAM, and the benefit of the declaration has to be given to him.
The suit, he has
Has to
made
be
the
given
party
to
to
him.
the board, my
And
lord.
the mistake is they should have in the first read they should have made the you
My lord,
formal party.
government has not made a party. In the suit,
And
government has
the
made not.
content testing also somehow.
Behind the back
correction
of the
has to be
government,
made
he has
by-
taken the order, my lord.
Fourth, you come with the instruction. He will not. I will give the benefit of this. You can't do that. There is a judicial process for small technicality. Why should he lose 2 years of service? Okay. Fourth, and you serve the board.
So I'll
Take out the notice during the course of the day and serve the board.
till that date.
Let it be 4th because
Yes, sir, 4th.
Saturday is also working, so you can do it. Board serve the board. Okay.
Sir, status quo as on date. at least-
No, my lord, I am opposing the interim order, my lord.
When are you going to retire?
Sir, tomorrow.
That's the whole difficulty. I can't pass the order like this.
Sir, only question is suppose you also said that I will not claim
I
any.
can put you in the same place. Don't worry. Monday. I'm here.
Can I, sir, only thing is, can you
Basically, you are.
can you say that I will not claim an equity? Suppose I will continue even without salary. I cannot claim,
Monday,
I will not claim an equity even if suppose I will lose my case.
No, that can't be because unless it's corrected, what can
Sir,
they do?
this is totally a very,
And
very.
contempt, three months time was given to contempt.
Sir, question is, as you know, the first contempt, second contempt like this. That's it. I don't blame anybody. The whole difficulty is without there is a declaration. That declaration has been now.
You give me last hour.
There is a board.
Monday, I'll pass the order. Don't worry. Monday, I'll put you back. Don't worry.
Sir,
I'll put you back. Yes. Your continuity will also be given.
sir,
It has to be given.
sir, can you us put some words that my continuity will be decided on that?
Yes.
My lord, no interim order, my lord. My trial, no interim order.
I'll just see the issue is pertaining to the correction of the date of birth of the petitioner from what is that? The petitioner is agreed by in the service record. Petitioner date of birth is entered as 28 1966. But the petitioner claims that in fact his date of birth is 12/6/68. Therefore, he has been litigating before this court by filing the repeated proceedings. Eventually, this division bench of this court relegated the petitioner to file a suit with suit seeking declaration. The petitioner filed a civil suit number 288 of 2022, which has been decreed by the Court of Senior Civil Judge Senior Division Cuttack, while its judgment and decree dated 31/1/2023. That is the date of birth of the petitioner is correct date of birth. Date of birth of the petitioner is 12/6/68, but not 20th of April 66. After the obtaining the decree, the petitioner again filed a writ petition before the court for implementation of the decree. The writ court allowed the writ court by the judgment dated 14/7/2025 allowed the same, directing the opposite party number 2, opposite party number 3, opposite party number 2 to carry out necessary corrections. The certificate, the certificate. Since the order was not complied by opposite party number 3, a contempt petition was filed. Contempt petition being 4569 of 2025 was also filed. The 14th bench of this court, by the order dated 24/10/2025, directed the alleged condemners, who was the director of opposite party number 3, director of opposite party number 3, to carry out the correction in the education certificate of the petitioner within 2 months, within 1 month, within 1 month without fail. Mr. Rautrai, letter counsel for the petitioner submits that despite the judicial determination and repeated orders by this court, the correction in the education certificate has correction in the educational certificate has not been carried out. As a result of which the benefit flowing from the decree is not has not been given to him, and he is going to demit office on tomorrow.
On 30th.
On 30th this month. Hence, he has approved this court. Mr. Issue notice. It is not going to be symbol that none of the proceeding filed initiated by the petitioner earlier, the state government was a party. State government was party. Unless the correction is carried out by opposite party number 3, the benefit cannot be given to the petitioner by carrying out necessary correction in the service book. In view of the aforementioned issue, in view of the aforementioned, no interim order could be passed, but it is made clear that since there is a judicial determination for correcting the date of birth certificate, the benefit of the same needs to be extended to the petitioner, as the declaration by the suit court has already attained finality. With finality. So leaves the matter on board for further directions. Yes, I have recorded that.
Yes.
And unless they come and say that
the
decree is attained finality, they might have challenged. Who knows? Yes.
Date 4th.
5th. Let it be 5th. Yes.
5th.
Yes. Next 23.
May I serve a copy of the board
Yes.
counsel?
Mr. Rautrai undertakes to serve a copy of this writ petition along with this order to the council appearing for opposite party.
Board. Paddy.
23.
Yes. 11, 12, and 13. 11 is the report prepared by the ADM.
11.
Impact number 7. 7 without authority.
What are you seeking by the way?
Seeking the report submitted by the
ADS, OP number 7 is illegal, and the communication issued by the collector and the DRCS also illegal, because prior to that, 3 inquiry was conducted by the collector himself and the ARCS twice, and found that the allegation of the petitioner was opposite party was illegal. Thereafter, so much of this report has been prepared under section 11, which is under challengement. Thereafter, the intimated the collector has given the direction to the DRCS.
What is inquiry is regarding what?
The cost, your lordship, I'm coming to the fact, man. Opposite party number 5 was initially engaged as a contingent mania, daily wage basis, and he was abandoned service and removed from his service. After 6 years, he claimed, 10 years, he claimed that I have not received salary from 2016 and 17. After the inquiry was conducted by the ARCS twice, thereafter the collector conducted the inquiry. It is found and everything has been done right. Now the ADM has prepared inquiry report under section 11 that he is entitled to get the salary from 2015 and 16, and the
we'll issue notice because salary their rights are involved.
No, I am coming to this. That was what is the claim. Annex of 2 help it.
I'll issue notice in any case.
Annex of 2, he is claiming
right, whatever right accrued to the private opposite party.
Claim is in year 15 and 16. Application by 23.
Maybe, but without hearing them, that claim cannot be discarded.
No, I'm not saying that. He's saying that 13-10-19 ପତ୍ରପାଳ ସେବା ସମିତିର ସମ୍ପାଦକ ମଧ୍ୟ ଆମର ଦରମା ଦେଇ ଅଟକାଇ ରଖିଥିଲେ. He himself saying that I'm 19 onwards, I'm not getting salary prior to that.
You are not a private litigant. You are the cooperative society. Salary is to be paid to the employees, and
your last time visualize. Is it
I'll issue notice. We'll see.
Farmers month.
We'll issue notice. Yes.
Now the problem is that, man, collector now the compelling the secretary, you deposit that.
Once you have challenged that, you withhold.
Your lordship, that
you say that you challenge it.
That protection may be given.
Yes. You are not an individual. You are a cooperative society.
So the money of the farmers.
Then if I don't know whether they are right or not, without hearing that, how can I say like this? It's a matter of salary of someone. No? I'll simply issue notice. There is no
protection of the lordship.
What? Salary of the employee, you want entry protection, I will not pay. What is this?
Your lordship, can visualize. He is claiming that I am 19 or
I don't know what is the authenticity of those things. I don't know.
Once the money
it's a matter of a few thousand or few lakh. What is the amount? You tell me. What is the amount?
Amount to 75,000.
75,000 is cooperative society. You state.
Another issue is that now he has withdrawn from his account 2013 and 14, and is now saying that I have not withdrawn after 10 years. That amount also covered.
We'll see. Since you are challenging this order, you need not implement. Who is going to? They will attach. What is the procedure of attachment? You tell me. Can he do anything? Can he do anything to you, collector? Can the cooperative society will be closed? What will happen if I will not give stay? What will happen? You tell me. Out of your experience,
how this amount will be collected? First of all, how this amount, huge amount.
See, it is somebody's salary. Without hearing how entitlement, okay, whatever financial entitlement of an employee, can I stay it without hearing them?
Once the money will be taken by the person concerned.
If you don't give, how will they take it?
Because
you have challenged it, you are not going to give it. How will they take it? They'll come and take it from you. Almira. I'll issue notice.
65. Who will conduct the inquiry?
Need to notice to both notice in writ petition as well as the interim application. Lease the matter on 15th and take out the notice to the who is appearing for state you will appear for all of them. And number 3 is cooperative society.
Number 6 is private opposite party.
I know. I am talking. 3, 4 will appear. 3, 4 government.
No, all are government.
No,
Except 6, all are government.
Okay. Take out notice to 6. 6. Within 2 days, lease the matter on 14th. 14th.
Your Lordship, your Lordship, you can visit.
The part I can't.
No course of
Will be
action.
harsh. This will be harsh.
That date, no course of action.
Who will take, why are you not appreciating? For the sake of asking, you are asking, who will take coursive action? Tell me, against you. What coursive action you are, what coursive action you are contemplating?
Yeah, power, he can arrest the.
Attach the cooperative society for 75,000. What are you talking? Out of your experience, you.
Power of the collector.
I know once the stage order is passed, this matter will remain for 20 years, 20 years in this court, and this man will be deprived of 75.
Fixing a particular date.
This is what is happening.
Till that date, no.
No, you come, it's matter of 75,000, why unnecessary?
He's not.
It's not going to prejudice. And after all, he was your employee.
No, he was employed 10 years back.
What great prejudice is going to cause?
He has every
And
right
next
to raise dispute before
item.
the register.
I have issue.
65 day watching the register is the competent authority.
Okay, we'll see. We'll see that. Yes, next.
Inquiry by register. Register may at any time.
Collector says pay the money of 75,000 rupees for that.
Separate no, that was 1 lakh already withdrawn. Again, they are saying that you defer.
Collector is your nodal officer. Yes. Next.
25.
May I please?
Yes.
Sir, I have challenged order 24 for 2026.
Pay
At
8, huh?
25.
Next 8 you are challenging.
Yeah, annexed 12.
12.
Well.
No, 12, there is no 12. Item number? 25. Okay, 20. What happened to 24?
Lordship, that
What 24 I've taken up? Yes. Yes.
there my pay has been refixed and direction has been given for recovery, alleging that some excess amount has been paid.
Recovery can't be man.
Yes. May I draw my Lord's notice? Annexed 1. Your Lordship, for a moment, your Lordship may say.
Where is the recovery notice?
That last part, your Lordship may say. But your Lordship, looking at page 48.
The right to recover.
Yes.
The excess amount. Inadvertent error in the office orders. That itself is against that.
Yes.
Mercy. Judgment mercy.
Mercy, also in our case, that Jogeshwar, sir, your
Okay,
Lordship.
issue notice. Written notice form 4. Since the
One
opposite party are contemplating recovery of the excess amount alleged to have been paid to the petitioner, alleged to have been placed on the due to the inadvertent error in the office order, as is reflecting from the operating part of annexure 12. There shall be no course action for recovering of the excess amount, if any, paid to the petitioner. Please the matter on. We'll fix it after immediately after.
May I pay in that order may be in course of that because tomorrow they will recover.
No, that's what I've said.
Yes,
I
yes,
have
ma'am.
said
Yes.
it.
Your
That's
Lordship, fix a date.
Messy, huh? Just judgment is messy, huh? Mr. Kuntia is relied upon the judgment of.
Jogeshwar, I am relying.
And another judgment, our own judgment is there.
My
Sitting with
the state of Odisha, Jogeshwar sir case, I am relying that.
Jogeshwar. And one more judgment also we passed that.
That
Jogeshwar Sahu. And our own High Court judgment, I was a party to the judgment.
yes, that
Jogeshwar Sahu,
since this is
relying upon Jogeshwar, because that the recovery cannot be effected. There have to be party.
other 3 judgments are
Immediately after vacation. Yes. Yes.
Hello, I will serve copy with respect to one and others to notice.
Yes.
Responded one.
No recovery.
Role line. We have no role. Gridco is a role.
Okay, let them come forward and say it.
We are the formal opposite party.
May I pay order copy in course of the day?
Yes, yes. One to pass. One, has he come?
Mr. Maran,
Then I'll take it up. Let him come. Let him.
please say instruction.
Shall I take it up at 2 o'clock? Why should you get detained? Let it be 2 o'clock. Yes. And you intimate him so that. Yes. Yes. 26.
26, may I please? Allegation is that While the informant taking tea, my lord, at the time the present petitioner came and
And what is the injury? Injury.
Yes, this is the injury report, certified copy.
Injury.
It's showing that
Lacerated. That move. Where does it say simple or what? Nothing is saying. Multiple.
swelling,
ଅମୁଲ
abrasion.
ପ୍ରଧାନ ହାତରେ ଧରିଥିବା କଟୁରୀରେ ମୋ ମୁଣ୍ଡକୁ ଜୋରେ ମାରନ୍ତୁ ଆକ୍ରମଣ
Hey, Golok Dali.
but not in the
Certified copy I have given.
Yeah, what are the injuries?
That is
Head injuries.
no, head injury nahi.
ମୁଣ୍ଡରେ ଜୋରେ
Say
ମାରନ୍ତୁ।
Neck.
back side ରେ ଅଛି
Swelling
ତାକି
back,
ଗାମୁଛାରେ ଭିଡ଼ିଲେ ଆଜ୍ଞା।
Yeah, yes. What are the allegations? What,
Yes.
how many of you are there? Oh, so many.
7 to 8%. While tea is you are taking tea, there is a push and pull. What is pass on my file?
And what are the antecedents?
Antecedent is concerned in the same self occurrence, 3 FIR has been registered.
Call for issue notice. Call for issue.
Lordship kindly see
And,
this order.
Petitioners to disclose the antecedent of antecedents. They are antecedent for filing affidavit. Lease the matter on 21st. In the meantime, no course of action. Yes.
Oh, bless.
Get the sheet here. Because 9 people are there. Injuries are. I have
injury
perused the injury report, the certified copy of the injury report submitted by which indicates that there are
swelling and
swelling
laceration.
injury and
Two
one
swelling and one laceration.
Insize wound. All are appears to be simple in nature. Therefore, entry protection, call for CD and chance. Yes, next.
Oh, bless. 27.
Your Lordship, in this case, 74 is the only non-rule of this, my lord.
70?
74, my lord. Outrages the modesty of a woman.
354.
But the case and counter case, fast
What
case.
is the sentence prescribed in 74? Less than 7 years? Less than 7 years. 74.
5 years. Case and counter case, both party admitted that due to civil dispute, this case was arises. And
Yes.
first FIR file petition number 5, my lord, under annexure 2, my lord. And there is no specific allegation.
Yes. That's it. Yes.
Petition number 5.
Yes. Patendra until and you put let the petition submits that except the offense under section 74 of BNSS, all other offenses invoked in the present case are bailable in nature and bailable in nature. In view of the same, he submits that he is entitled to anticipatory relying relying of the judgment of Satendra until and Patnis Kumara. Yes.
Published.
Okay.
Allow me, Lord.
Hello. Yes.
28.
Now, alleged offense 109 of BNS and other offenses, my lord. Lord, fact is that brother of an informant
injury, show me the injury.
Injury as per my instruction is simple, my lord.
Yes.
Bounce of Thengare Badela. This is the allegation. Fact is that the brother of an informant has tinned up the daughter of a petitioner number 1. Thereafter, quarrel held, my lord. This is the allegation. This is the fact on page 9 written affair is there, my lord. ସାନ ଭାଇ ବଡ଼ ଭାଇ ଉଭୟ ଯାଇଛନ୍ତି କି ନାହିଁ ସେ ବିଷୟ ମୁଁ ବାପା ମା କେହି ଜାଣିନୁ ଉକ୍ତ ଘଟଣାକୁ କେନ୍ଦ୍ର କରି ଦିଲ୍ଲୀପ ଦାସ ଦ ପିଟିସନର 1 and ପଦିଆ ଦାସ ଦ ପିଟିସନର 2 came and
ଗୋଡ଼କୁ ବାଡ଼େଇକି ଭାଙ୍ଗିଦେଲା.
Yes, madam. This is the allegation, madam.
Fracture injury must be severe.
Grievous injury, but in the knee, not in the.
So me grievous. Not simply grievous. Grievous one.
Not a
Antecedent?
No antecedent.
Where have you said that?
Para 3 lakh. My petitioners are innocent of crime. They have never been implicated in any case.
Where have you said that?
Paragraph 3, my lord. I have
Paragraph 3.
Yes, ma'am.
Also, allegation of the petition also. In paragraph 3 of the petitioner has specifically mentioned forum. The state council has brought the notice of this court to the.
Never been implicated in any case. Previous.
It's provisional of the same inclusive that one of the injury is the grievous in nature, but it is not in the vital part of the body. The petitioner is to have used petitioners is used to for assaulting. What is Archana? What is his name? Barik. Chanti Barik. What is the name of the informant?
Ranjan Barik.
Ranjan Barik.
Yes, ma'am.
Who is the injured?
Injured is the mother of Ranjan Barik.
What is the name? Ochanti.
Yes, ma'am.
Ochanti Barik. Ochanti Barik. Mother of the informant. Yes. The guardian. Yes. Next.
29th.
May I please?
Yes.
In under section 126(2) and 117, quarrel between two brothers mela. ଖାଇବାକୁ ନେଇକି ସେ ତା ପାଇଁ ସାନ ଭାଇ ପାଇଁ ଖାଇବା ଥିଲା, ବଡ ଭାଇ ଖାଇଦେଇ ପଳେଇ ଆସିଥିଲା. Actually, real incident.
17. What's the corresponding?
Mela?
Corresponding offenses.
Voluntary causing to grievous hurt, my lord.
326.
What are the injuries?
ସେ allegation କହୁଛି ଯେ ମୋ ହାତକୁ ବାଡେଇ ଭାଙ୍ଗିଦେଲା, କିନ୍ତୁ ସେ ବାଡେଇକି ଭାଙ୍ଗିନି.
You have the injuries report.
ଠେଲା ପେଲା ହେଇକି ପଡିଗଲେ ଦି ଭାଇ.
Both of them are brother.
Yes, my lord. Informant is the younger brother and the victim is the elder brother.
Fractured.
Fractured.
This instance up to the brother of the petitioner, the fact number from show registered, eligible petitioner shown so. The state council is discharged, admitted to hospital. Admission date. No. When was he discharged? Remaining in hospital on 7th, huh? 7th March to 13th March. On March to 13th March. The injury report, which appears to be, which indicates that the injury is simple in nature. Huh? Yes.
Item 30.
Allegation against more than 20% against the villagers, 109 and other allied offences. ଦୋଳ ମେଳଣରେ ପଡିଆରେ by exchanging of hot words.
What is the injury?
There is a two groups. There are distributed two groups, and there are two personal injuries. One is simple and another is grievous.
Grievous.
Grievous or simple.
ହାତ ଭାଙ୍ଗି ଯାଇଛି ବୋଲି allegation କରୁଛି.
So many people are there. What are the antecedents of these people? 15, 18 people. Antecedents.
Antecedents to my lord.
18 people have come. You have to give me the details of grievance. File affidavit, Monday. Fifth. File affidavit. Affidavit regarding the antecedents. Yes, next.
My lord,
Fifth.
I may be protected.
Fifth, no. 18 year. You should have filed.
My lord, they have
There
taken
may be some murderer also. There may be some rapist also.
my lord.
And
But
this
on-
is the strategy. And you want anticipatory bail without disclosing anything regarding the antecedent.
They have on instruction, there is no antecedent. For that reason, I have not mentioned it.
Thereafter application will come. You should have filed separately instead of, yes.
31. My lord, fifth,
Fifth. File the affidavit. Of all the 18 people.
31 Arjun.
Disclosing, yes.
Arjun, would.
32. 32, yes.
Under section.
What are the allegations? Tell me.
ଆଲିଗେସନ ସେ ନଡା ରଖିଥିଲେ ସେଇଟାକୁ ପୋଡିଛୁ ବୋଲି ସେଇ ଆଲିଗେସନଟା ଅଛି କିନ୍ତୁ ପୋଲିସ ସେଇଟାକୁ ଘର ପୋଡି ଆକାରରେ ସେ ଅଫେନ୍ସଟା ଲଗେଇଛି 326G ଲଗେଇଛି ସେଇଟା ଘର ପୋଡି ହିସାବରେ ସେ କିନ୍ତୁ ନଡା ରଖିଥିଲା ଛତୁ ଚାଷ କରିବା ପାଇଁ ସେଇଟା ସେ ପୋଡିଛି ବୋଲି ଆଲିଗେସନ ଅଛି FIR ରେ।
This is life sentence. Life sentence. Yes, call proceeding. Call proceeding. Next. 33.
Matrimonial offences, Miller. In this case, this is the entire concept of story, the FIR story.
The FIR, what are the allegations corresponding? 109 is there.
109 is there,
Yes.
but there is no simple any injury, even not a single injury. She's saying that they tried to kill her by putting a pillow, but Millard, I have filed a divorce case in the on 2nd of January. Thereafter, in the month of March, after receiving notice, this FIR concocted story has been instituted. I'm an assistant executive engineer.
Who are you?
I'm the husband and in-law members.
At the instance of the wife of the petitioner number 1, the present FIR has been registered for the following allegations. Petitioner number 2, 3, and 4 are the in-laws of the informant. As for the petitioner submits that the petitioner number 1 initiated a civil proceeding under section 13(1)(a) and 13(1)(a) of Hindu Marriage Act in the month of February.
In the month of 2nd of January 2026 this year.
2nd January 2026, and a counterclass to the same proceeding. What it is, wife of the petitioner number 1 has cooked up the story and filed the present FIR. Reading of the allegation in the FIR and the other document placed before this court indicates that the dispute is essentially arising out of a matrimonial dispute. Hence, yes, next. 34.
Pardon, my lord. I don't 31 is student, my lord, protect me.
Yes, reverse way. How can I take the matters? I have done whatever you're supposed to do. Yes, next.
I'm on visa from Virtual High Court, Kalahandi, my lords.
Yes.
My lords, section under 115 of BNS, my lords. Event is, my lords, the bhai vitra dispute, my lords. Complainant au petition number 1 bhai, my lords. Kichi property dispute by they have from heat argument, tabade complaint case issue, my lords.
What are the injuries?
Injuries?
Using dangerous weapon, extortion. What is the weapon use?
Weapon, my lords.
Dharua Koturi. Your brothers, huh?
Yes, my lords. Petitioner 1.
What is the relationship in informant and the petitioners?
Brother. Our petition number 2 taro sana bhaira puo.
Robinaran Behra. Robinaran Behra is
Sunakar Behra.
They are relatives. 226.
Out of
The brother of the Krishna. The informant in case is the brother of the.
Earlier they are filed the bill another bill number another in the certificate they are stated that one bill was disposed of.
What happened?
25/11/25.
Yes, yes, you had earlier approached this court.
Matlab, due to some issues, matlab, they are unable to court and communicate.
How would you maintain the second one? The same cause of action. What is the changing circumstances?
That the order was for the event
Yes, that's there I have seen now. That
allow
petitioners have earlier approached this court by filing AVPL number 13234 of 2025, which was partly allowed, which was turned down, disposed of by order dated 25/11/2025, directing the petitioner to surrender, giving giving liberty to the petitioner to surrender before the trial court and move for regular bail plea. Without complying the same order, the petitioners have repeated the present applications. Hence, I am not inclined to entertain his petition. However, it is open for the petitioner to surrender before the court below and move for regular appeal application. If such appeal application moves, same shall be considered on the same day. Yes, next. Yes, same dispose of. They will surrender and yes, next.
35.
That is the order earlier also.
The earlier order, if that last part. Previous injury that is,
Yes.
order shall not be given effect.
Yes. 35.
My lord, present prisoner is two co-accused person. My lord, prisoner co-accused person and 2 and 3 no criminal action. My lord, civil injury ଅଛି prisoner accused ନିକୁ ଆଣା ତାର ବେଲ ଫାଇଲ ପଡ଼ିନି my lord.
307, but we didn't have CD and injury report.
What are the injuries? Do you have that?
No, no, I didn't.
Call for CD. Call for CD. Yes. Okay. Next. Yes. Call for CD next time. 40. Yes. 36. This is.
Lordship, I want this year.
63 kg, 150 gram of ganja.
163.
163 kg.
Your Lordship, FIR dated on 20 December 2023, Your Lordship, and the FIR against unknown person, Your Lordship. The present petitioner is the previous owner, Your Lordship, of the vehicle, offending vehicle. And the month of January, this petitioner came to know about this FIR, Your Lordship. Prior to this FIR, Your Lordship, on 20th October 2023, the vehicle was sold by virtue of an agreement as Annex 2.
Charge sheet has been filed? No.
Charge sheet has not been filed.
These
Hospital
people are
interrogation would be
concerned with-
required whether that the selling of that vehicle, whether it is true or not. And 163 kg of ganja.
Your Lordship, kindly see, peruse the Annex 2, Your Lordship.
You surrender apply for regular pay. That's the only thing. The petitioner petitioner is apprehending arrest in connection with the FIR number so.
Your Lordship, kindly pending amount 75,000 ଥିଲା ସେଥିପାଇଁ Your Lordship accident transfer ହେଇପାରିନଥିଲା.
What is the recovery?
163 kg, 150 gram.
In view of the huge quantity of contraband recovered, I am not inclined to entertain this anticipated way. However, it is open for the petitioner to surrender for the court below and apply for regular bill if same day. Courts will not same day. Yes, next.
37.
The POCSO.
If you notice.
13 years, she was
So it's a
pregnant.
Notice. Next. 38.
38.
Yes.
Petitioner before your lordship is the mother-in-law and brother-in-law. My lord, this is a mentally disordered person, my lord, who deceased, and she is undergoing treatment.
No, she has, in the meanwhile, she has died.
Case converted. I have already written in my paragraph in all the averment, my lord, that the case has.
Call for CD. You have call for
No,
CD. This is the matter on 5th. Yes, next.
My lord, in that date, my lord,
302.
because my lord, she committed suicide. She committed
Morning
suicide
injury.
and her dying declaration has already been recorded. And
Let it come. You have dying declaration, show me.
no, I have not the copy.
Let it come.
ମୋ ପାଖରେ ଖାଲି କପି ଅଛି ଯେ ସେ mentally disorder and she is undergoing treatment since long by the family member of the
You are
petitioner.
telling everything orally. I want to see his phone record.
Documents ଅଛି କିନ୍ତୁ dying declaration copy ନାହିଁ, but I have the document.
Next.
My lord,
39.
ନହେଲେ ଖାଲି lady ଟା my lord entry protection ପାଇଁ prayer କରୁଛି lady ଟା my lord.
302. 302.
May I please your lordship, my lords. Offense under section 3032, my lord, this is a 379 allegation, my lords. On confession of the co-accused statement, petitioner has been implicated, my lords. And my lords, illegal transportation of stolen sand, my lords. And the driver stated the name of the present petitioner as per the direction of the present petitioner. That's all.
Vehicle, you have vehicle.
My lords.
Vehicle.
ଛଅଟା antecedent ଅଛି similar kind.
ये होची my lord kindly last for a moment, my lord. Same day रे तीनटी केस कले मोर गोटे केस मते अरेस्ट करी फॉरवर्ड कले मो आगे 15 दिन रहिली 7 8 9 आउ दुईटा केस रे फॉरवर्ड लगेले रिमांड लगेलेनी
ତାପରେ 4 7 21 15 18 26
दीटा माइलर
छटा
माने गोटे दिन रे माने काली क्लास ऑर्डर कॉपी इज विथ मी काली क्लास
Whatever, but there are 6 antecedents, no
माइलर्स
antecedents.
एंड अनदर गोटे दिन रे आगे केस कले मु 15 दिन भीतर रहिली माने काली क्लास arrested in Chandanpur PS case number 7 of 2026 was in custody nearly 49 miles and after being released he is being served further cases miles.
You appear, you can get any accused is granted bail.
Miles.
The co-accused has been granted bail.
ना ना गोटे सोल मुदला
Your
मते
driver has been arrested or
ना ना ड्राइवर को आगे मुदला करलेनी मते केवल मुदला करले माइलर्स प्रकाश स्वामी
ମୁଦଲା
this is there miles
ସେମାନଙ୍କୁ ନୋଟିସ୍ ଦିଆ ହେଇଛି 41 ନୋଟିସ୍.
You must be driving.
ना ना मोर
Driver plead away.
ना ना ड्राइवर को छाड़ देले माइलर्स
vehicle ତାଙ୍କର vehicle petitioner ନା
Employing the many cases माने
माइलर्स होची
habitual.
गोटे दिन रे तीनटा सिमिलर नेचर केस करले गोटे केस मते अरेस्ट करले 15 दिन रहिली 7 8 9 माइलर्स केस तापरे 7 रे अरेस्ट
You surrender same day. Surrender same day and you oppose.
अरे काइंडली
So let you obtain the case that on the basis of the case that disclose that the petitioner has been number of incident and not inclined to prevent this case which is chosen for this petitioner to surrender same day by both the courts below. Yes.
माइलर्स दिस इज माइलर्स काइंडली ग्लास द ऑर्डर माइलर्स Chandanpur PS case number 7 of 2026 miles. Police arrested the present petitioner miles. And on same day manner 3 FIR is registered. 7 गोटे 8 गोटे 9 गोटे 7 रे अरेस्ट करले 15 दिन रहिली 8 9 रे मते रिमांड लगेलेनी तापर मु आगे आसिली 9 केस फाइल कले
Tell of these things same day bail application will be disclosed.
ग्रामनाला दबनी माइलर्स
Same day both the courts below. That's what I
आगे से कंसिडरेशन करियन कले हजूर देबेनी माने से देबेनी आगे माइलर काइंडली
then otherwise I have to reject it. Yes.
Ernest Kumar versus State of Orissa that decision.
And for the petitioner to rely upon the judgment of Ernest Kumar and yes. Item 40.
Let the offense under section 296B 3184 3513 of BNS 2023.
What are the allegations?
Allegation the petitioner had taken 30 lakhs rupees from the informant and the petitioner had shared the informant to sell a plot bearing number 5514 Veladri Vihar Mauja Chandrasekharpur Bhubaneswar. Then the petitioner had not registered the plot in the name of the
CD and CA would be required. CD and CA would be required.
Actually, the fact is that actually no, so the petitioner did not know the informant in the what the time they said. The petitioner came to know the petitioner in December 2019, but he demanded in the FIR that the transaction is done in March 2019. And Millard, the actual fact is that the petitioner
Call for the CD on 5th and take it off. 5th. Okay.
Interim protection Millard may be granted, which is Millard interim protection Millard may be granted. Millard interim protection is a hard question Millard.
Yes.
41.
May I please, madam? Allegation of stolen of illegal stand, my lord. Omnibus allegation against a group of villagers, my lord.
What are the injuries? 109.
109 is there, my lord. In similar situation, page 13, annex 2, some of the co-accused released on bail, not named in FIR, my lord. Allegation group of.
In the same FIR?
Yes, my lord.
Co-accused, there are co-accused.
Yes, my lord. Page 13, annex 2, my lord.
Co-villages ମାନେ ଯାଇଛନ୍ତି similarly circumstances.
Additionally, there is same land. Same land. Annex 2 ଅଛି. Annex 2 ଅଛି. Orders. Co-accused persons approach this court by filing ABP at number 14696 of 2025, which was allowed by the coordinate bench by the office dated 24/12/2025. Calls for the petitioner seeks clarity with those petitioners in the petitioner as the case is similar.
42.
This is under section 496B, 316(2), 351(3). Mother is the informant. Mother has lodged the FIR against the daughter and son-in-law. The civil suit is pending and mother is compelling the daughter accused number 1 to relinquish her share in favor of her son, where he states. So that is all denial. She has lodged the FIR and all these cases are false and the sections are not at all at present.
What is the allegation?
Allegation is that he divided the accused number 1 divided the family and took 6 lakhs for maintaining the civil suit. Civil suit is pending, my lord, annex 2 series. That but he is the informant, the accused person is not the plaintiff. Brother is one of the plaintiff and the defendant. He said not.
Yes, madam. Family dispute. Family dispute.
Family dispute.
Family dispute.
Mother of the petitioner number
1.
The FIR has been registered by the mother of the petitioner number 1. Mother of the petitioner number 1. Petition number 2 is the husband of petitioner number 1. Son-in-law. Son-in-law of those. And the counsel for the petitioner drawing the detention of this court to the proceeding, civil proceeding, pending in the court of senior division Bhubaneswar, submits that the dispute is essentially regarding the family property, regarding to the nature of allegation and so on. So yes. Yes.
43.
Yes.
May I please, Your Lordship? Your Lordship, in this, the allegation is while the excise inspector, along with other officials, while patrolling, they came across a vehicle loaded with mahua flowers. So after that, the present petitioners, along with they have, as per the allegation, they have assaulted the excise officials, and all the offences are triable by magistrates, and all the offences, yes.
Outside submitted all the offences against the petitions are tribal magistrate. Yes.
44.
Obliged, Your Lordship.
Yes. Offenses 296, D subsection 5, 318 clause 3, 319 clause 2, and 351 clause 2. 294, 54, 418, 419.
What are the allegations?
Lordship, see at page 9. On the date of occurrence, that is 9/3/2026, the informant and 4 of his friends, they had been to Puri. And while
ଚାକିରି ଦେବେ କହିକି ପଇସା ନେଇ ଯାଉଛନ୍ତି.
their house on the train, they had the occasion to meet with the petitioner and one Shyam Sundar Satpathy. It alleged that in the train, by way of conversation, they have come contact each other, and the allegation is that petitioner along with another, they have assured them to provide job under the Odisha Staff Selection Commission. On that pretext, allegation they have paid me 10 lakhs, me and another 10 lakhs. That is what the allegation.
You have taken money from how many people?
5 ଜଣଙ୍କର ଷ୍ଟେଟମେଣ୍ଟ ଅଛି ଆଟଲିଷ୍ଟ ଯେଉଁମାନେ ତାଙ୍କଠୁ ପଇସା ନେଇଛନ୍ତି ବୋଲି ଆଟଲିଷ୍ଟ 5%.
How many cases are registered?
ସିଏଟା ଆସିନି ଷ୍ଟେଟମେଣ୍ଟ ଯୋଉଟା କାଲି ଆସିବ.
He has taken money from these 4 people.
No, they have alleged. You also imagine all of a sudden they had the occasion to meet in the train itself.
Account number is
they have paid it or not?
Oh, so that
Then
15 lakhs.
15 lakhs you have taken from these people. And from other people also you have taken, promising them to pay.
ସବୁ ଯାକ account ରେ ପଇସା
arrange it
ଦିଆ
off.
ହେଇଛି।
That's what
Let
the
910 taking.
5 statement. Get the CD and tell me how many cases are there.
No case to my issue.
No, you see. From the-
Your lordship disposed of offense on.
Dispose of same day the bail application will be, because by that time everything will be there.
Yes.
Yes. Next. 46.
The offense under section 74, 75 of the PNS Act, and there is a case and counter case, my lord. The petitioner after lodging the affair, she has.
That's the allegation. Yes, Mr. Naik.
My lord, kindly have a glance to the allegation in the FIR. While the informant is the lady standing in the queue in a bank, the petitioner touched on her sensitive parts, my lord, and that was recorded in CCTV.
That was not
That
recorded,
is
my lord.
allegation.
What is the counter? What is the counter allegation?
Counter allegation, my lord. That counter case registered after long time.
It is 354 only.
Yes, my lord.
Yes, 354.
354. Then unless cover.
No, 75 to sexual harassment.
What is the sentence?
3 years.
Then 7 years, less than 7 years. Then Arnish Kumar and the guideline will be followed. Okay. Satyendra Until and Arnish Kumar follow. Yes. Next. 48. Cross case. I'm going to cross case also. Right on.
My lords.
There is a cross case registered by him against the informant in the insurance case, which is based from the court against the two to the petition. Yes. 48.
My lords, the present.
Yes. 48.
Yes, my lords.
Yes.
The present case is a matrimonial dispute between the husband and wife. I am the husband
And
Yes.
48, yes. Yes, my lords. And I have been falsely implicated.
Who are you?
I'm the husband, my lords, and applying for anticipatory bail. I have no antecedents, and it is a.
What are the allegations?
Sir, 115, 296, and 85, 498A has been misused in this case. So I may kindly be granted anticipatory bail.
The petitioner has one criminal antecedent. I am placing the statement of mother of the petitioner. 48.
It is only matrimonial issue. There is nothing.
My lord, that is
Yes.
one. My friend submitted that he has no criminal incident. Petitioner has one criminal incident. I am placing the statement of mother of the petitioner. Mother is Shanti Naik. ଗତ 9/3/2026 ରାତିରେ 10ଟା ବେଳକୁ ମୁଁ ମୋ ସ୍ୱାମୀ ଏବଂ ଅନ୍ୟ ଏକ ଘରେ ପୁଅ ବୋହୂ ସମସ୍ତେ ଖାଇ ପିଇ ଶୋଇଥିବା ସମୟରେ ହଠାତ୍
Kindly it may be granted, sir. Injury report nahi, sir. Matrimonial dispute it usually happens, sir.
And 109 is also not.
No, 109 is not there. But my submission is the mother of the petitioner states.
Matrimonial petition. Who is the informant? The
Wife.
At the instance of the wife of the petitioner, the FIR has been registered for making following allegations. The reading of the allegation as reflecting from the FIR indicates that the dispute is essentially matrimonial in nature and granted. Yes. Yes, sir.
59. Pre-bail application.
Allegation against the present petitioner man ଗୋଟେ ଡିସମିଲ ଜମି କିଣିବା ପାଇଁ କଥା ହେଲା 6 ଲକ୍ଷ ଟଙ୍କା 4.5 ଲକ୍ଷ ଟଙ୍କା ନେଇଛନ୍ତି ଆଉ 1.5 ଲକ୍ଷ ଟଙ୍କା ଦେଇନାହାନ୍ତି ବୋଲି allegation my lord. In this case my lord, after registration my lord,
All the three cases same allegation.
my lord,
Yes.
ମୁଁ ସାକ୍ଷୀ ପଢିଥିଲି
ଓଲ୍ଡ ୱିଡୋ ଲେଡି ତାକୁ ଏଗ୍ରିମେଣ୍ଟ କଲେ ସେ 6 ଲକ୍ଷ ପାଇଁ 4.5 ଲକ୍ଷ ଟଙ୍କା ଦେଲେ ଆଉ 1.5 ଲକ୍ଷ ଟଙ୍କା ଦେବା କଥା ଦେଇନାହାନ୍ତି ତାକୁ ରେଜିଷ୍ଟ୍ରେସନ ଅଫିସ କି ନେଲେ ରେଜିଷ୍ଟ୍ରେସନ କରିଦେଇ ଯେମିତି ତାକୁ ଦେଲେନି ଏ କମ୍ପ୍ଲେନ କଲା ସବ ରେଜିଷ୍ଟ୍ରାର ଅଫିସରେ ପଇସାଟା ଫେରେଇ ଦିଅନ୍ତୁ ବୁଢୀ ଲୋକଟା
ପଇସା ଜମି ରେଷ୍ଟ୍ରି ଆଜ୍ଞା ଆଉ ଜଣେ ଦଲାଲ ମିଶିଲେ କହିଲେ ଅଧିକା ପଇସା ଯିବ ତୁ ଦେ ସେ ନାଇଁ କେସ୍ କଲେ ମନାରେ
ସେ 1.5 ଲକ୍ଷ ଯୋଉ ଦେଇନାହାନ୍ତି ସେତିକି ଦେଇଦେଲେ
ପଇସା ଦେଇଦେଇଛନ୍ତି ପଇସା ନେଇ ସାରିଛନ୍ତି ପଇସା ନେଇକି ସବ ରେଜିଷ୍ଟ୍ରାର ରେଷ୍ଟ୍ରି ହେଇଗଲା ଆଜ୍ଞା my lord kindly see registration ରେଷ୍ଟ୍ରି ହେଇଗଲା ଯଦି ହେଲାନି 19 ତାରିଖ
ସବ ରେଜିଷ୍ଟ୍ରାର ଅଫିସରେ ସେ ଯାଇ
Then what is the grievance?
I have not received
1.5 ଲକ୍ଷ ଟଙ୍କା ଦେଇନାହାନ୍ତି allegation 1.5 ଲକ୍ଷ ଟଙ୍କା ଆମେ କହୁଛୁ ସବୁ ନେଇଗଲା ପରେ ରେଜିଷ୍ଟ୍ରେସନ ହେଇଗଲା ସବ ରେଜିଷ୍ଟ୍ରାର ପାଖରେ ଆଡମିଟ
She is the owner.
She is the owner man.
Then she can file a suit for cancellation.
My lord,
non-payment of.
my lord.
Then the sale will be invalid.
My lord.
All the three. All the three same.
My lord, my lord.
Same
ଦି ଜଣ ସାକ୍ଷୀ ଜଣେ ଉନ୍ନର
ଜଣେ ସାକ୍ଷୀ
କି ସାକ୍ଷୀ?
ସାକ୍ଷୀ ପିଟିସନ ନମ୍ବର 1 ଫାର୍ଷ୍ଟ ପିଟିସନ
ବଳରାମ ମଲ୍ଲିକ
ମାନେ ସାକ୍ଷୀ ୱିଟନେସ୍
and
ବିଜୟ ହଉଛି ଉନ୍ନର ଯାହା ନାଁରେ ଜମି କିଣା ହେଇଛି
purchaser.
ପର୍ଚେଜର
And what is Sibo
ହଉଛି ସାକ୍ଷୀ
Prasad and Balram Malik are the witnesses to the sale transaction, whereas Vijay Kumar Malik is the purchaser, and the informant is the seller of the land. The allegation is after the sale deed is executed, sale consideration, total sale consideration has not been paid. Yes. All the payments, yes.
Item 50. Case of kidnapping a minor girl, though the offence is now available in nature, the police may add higher offences. In the meantime, both the guy and
Victim
boy
not
and
rescued.
girl married and
Rescued.
she
Victim
rescued.
not rescued.
No, she rescued. Married
Both the case diary is victim not rescued.
But I am, my lord, submitting my lord. My learned friend take instruction. She is in our house because marriage is there.
Pathan to 164 state.
Yes, my lord. That's why my lord I am saying you lord direct for 161 state.
Where is the FIR?
FIR my lord on Annexure 1 my lord page 7.
Please.
7.
Item number
50.
50. No FIR.
Your lordship direct for
FIR available.
Kahin FIR kahin? Annexure
Page 7.
page 7 my lord.
Huh?
Page 7.
There is nothing, just see page 7.
Right?
Blank paper.
नहीं,
Yellow
हम
paper.
तो कर- हम तो कर-
Just see.
ये-
See from here.
from
From there.
मैं କରିପାରିବିନି। ଓ ଏଟା seal cover ଆଜ୍ଞା ଅଛି your lordship କାହିଁକି that is the problem my lord there number ହଉନି ସେଥିପାଇଁ
Oh.
seal cover ରେ ସେଟା ଆସିଥିବ
Only
inside the seal cover ଆଜ୍ଞା
cover is there.
in view of the supreme court decision
No, it is in the only cover is there.
ଆଜ୍ଞା
Cover is scanned. And what is the age of this girl?
17 17
What is your age?
ଆଜ୍ଞା 19 ଆଜ୍ଞା କଲେଜ ଦି ଜଣଙ୍କ କଲେଜରେ ପଢୁଛନ୍ତି ଷ୍ଟୁଡେଣ୍ଟ ଏ କଲେଜକୁ ଯାଉଥିଲା ପଳେଇଛନ୍ତି ଦି ଜଣ ସେମ୍ ଏଜ୍ ମ୍ୟାମ୍ ଷ୍ଟେଟମେଣ୍ଟଟା ରେକର୍ଡ ହବ ରେକର୍ଡ ହେଇକି
Robi Naik. What is the name? Murtunjay.
ମୃତ୍ୟୁଞ୍ଜୟ ଆଜ୍ଞା କେବଳ ତାର ନାଁ ହେଇଛି ବାପା ମା କାହା ନାଁରେ ହେଇନି ସେ ଆମ ପାଖରେ ଅଛି ବାପା ବି ତାର ରାଜି ବର୍ତ୍ତମାନ
You should notice no course of action. Sorry.
You also can direct the petitioner to
Again,
produce the victim before the IO.
Issue petition also. Let consider the petitioner submits that the girl who is alleged to have been kidnapped is staying in the house of the petitioner itself, and he staying in the house of Mr. Naik, and counsel for the state submits that the petitioner is expected to produce the girl for the purpose of recording her statement on
183 BNS.
183 BNS.
ଦିଟାଙ୍କ
BNS.
ସେ ଗଲେ ସବୁ
This is the matter on 8th. In the meantime, no course of action subject to the petitioner extending all cooperation to the investigating officer for further investigation. For the investigation and recording of the statement of the victim girl.
ଆਦਰ ଗୋଟେ ଜିନିଷ ହବ ଯେହେତୁ ଭିକ୍ଟିମ ବର୍ତ୍ତମାନ ମାଇନର ଅଛି ଆଉ ତ କଷ୍ଟଡି ଦେଇପାରିବେନି ଷଷ୍ଠ ହୋମରେ ହିଁ ରହିବ
That's the problem. You will be in trouble.
ସେ ଚାହିଁବ ତା ବାପା ନବେ କଣ
Whatever.
ଅଲଗା ଜିନିଷ
Keep it on 21st. Keep it on 21st. Longer time. Yes, I'll just come.
The Lordship, the case is covered under the judgment of this Honorable Court. The State of Orissa.
Yes, yes.
It has to be established.
Para 23. SC, na?
Yes, yes.
Yes, 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 state, madam.
Then follow the.
Yes.
Yes.
Yes,
Para 23. Pramod Rai. Pramod Rai versus. Mr. Pramod. Yes, next.
Hon'Ble.
52.
Your Lordship, my lord, the offence challenged under section 126, 115, B 15 to 117 to 109. The matter arising out of a quarrel between the two minors. Thereafter, the one of the
My lord,
one
it
of
will
the
be guiltless in nature, but the case should not be registered because I am placing the statement of the injured, my lord. Self-inflicted. ପିଲାମାନେ ଖେଳୁଥିଲେ ସେ ନିଜେ ପଡି ତା ହାତ ଭାଙ୍ଗିଗଲା ମୁଁ ଇନଫର୍ମାଣ୍ଟ ଷ୍ଟେଟମେଣ୍ଟ ମୁଁ ଶୁଭ୍ରଜିତ ସାହୁ ଦୁଇ ଜଣ ମିଶି କମ୍ପିଟିସନ ମ୍ୟାଚ୍ ଖେଳିବା ସମୟରେ ମୁଁ ଶୁଭ୍ରଜିତ ସାହୁକୁ ଖେଳରେ ହରାଇ ଦେବାରୁ ମୁଁ ଏବଂ ଅଭିନନ୍ଦନ ପାଣ୍ଡେ ଦିବ୍ୟାଂଶୁ ବେହେରା ମିଶି ଖୁସିରେ ଦୌଡୁଥିବା ସମୟରେ ମୁଁ ପଡିଆରେ ପଡିଗଲି
By pointing out to the statement about the victim recorded under section 161. 161 CRPG, what is BNS?
Rishant Naik.
482. 482 BNS is, Mr. Naik submits that the informant himself is
Informant. It has injured.
Injured. That's stated that the injury
fell down.
He sustained the injury while he was playing, with other friends regarding it. Yes, next. 53.
21B of the NDPS Act, my lord, was possession of cough syrup proceeds from the other co-accused on whose confession he had implicated, my lord. On confession with the police,
what is recovery?
Cough syrup bottles, my lord.
My lord, the petitioner fled away from the spot. 2700 cough syrup.
From whose possession they have been released on bail, my lord.
Okay, sir. Same day. Mr. Albright grants also for the petitioner, taking me to the order dated 18/3/2012, passed by the coordinate bench in VLAPS number 1136/26 and 1308. The freedom of co-accused persons have already been admitted to regular bail by this course. We are being here to the convention submission, although are not in the recovery of the cough syrups, content of cough syrups. And move for regular bail. Such bill application seems that the courts below the same day. Yes.
And same day, my lord.
Same day.
Maintaining parity, my lord.
Correctly.
Yes.
54.
I will pardon for the Miller that the occurrence was 1/3/2026 में आया। FIR was lodged on 4/3
Yes, what are the allegations? FIR is not
Head injury.
Head injury.
Case date is not there. The delay ର reason से question ମୁଁ ଏବଂ ମୋ ସ୍ତ୍ରୀ ହସ୍ପିଟାଲ ରେ ଟ୍ରିଟମେଣ୍ଟ ହଉଥିଲୁ ସେଥିପାଇଁ ଦେଇ ପାରିଲୁନି।
हमें FIR देला पर not being registered, then we implemented it very day. एक दिन जो ये है ना जो हमको मारी साइला पर हमें FIR को खाना
What the weapon is?
खंडा।
और जो आस्त्री इंजन टा नहीं जाने वाला नहीं
Sir, the same day.
Might not on the one again, I think, only Topon against the allegation, other word of simple.
Whatever.
They should do,
What are the antecedents
Might
of these
not-
people?
not-
receive the case study.
Incident
Safety
nine.
ଦେଖିଦେବେ ଆଉ।
Huh?
Incident
Same day
nine.
ସେ
Subject to verification of antecedents and all, same day the bail application will be disposed of. Yes,
Other side, do no allegation. Other एक दो तीन.
it's all right. He had injury, showed injury and
नहीं छोड़ो only one. Topon ना छोड़ा है. अनुमान का तोड़ा. बड़े बेटा injured नहीं कर. My lord, my petitioner sir. My petitioner sir, 1, 2, 3, and 4. Only against Topon one. That is the short order धरना. उन्हें तोड़ा भी.
same day कौन से verify करदेବେନି।
same day considered by all
Someone
the
shall not get it.
courts below, all the courts below same day. Yes, next.
55.
55. Next. Yes. 55.
Case diary भी on
No.
that day case diary भी available my lord.
Yes.
No, how नहीं मुँह थारे सारे
हाँ,
case
case
diary ऐसे.
It is goes without tire करें तो it is expected that the prosecution service will produce the case diary before the trial court. Yes, on the same for the purpose of deciding the application. Yes. Next. 55. None appears. None appears in the interest of justice adjourned. After 2 weeks.
When my lord?
Adjourned. Nobody there.
56. Name please, Your Lordship. Objection 109 BNS corresponding to 307 IPC. There are 4 petitions in this case. Lordship, kindly see page 14, the injury report. There are 2 number of injuries. That is simple nature, one abrasion and lacerated.
What about by iron rod and scalp injury there?
Page
But
14.
injuries are lacerated.
Lacerated.
Lacerated, one abrasion.
One contusion and 2 lacerated. One contusion and 2 lacerated. And what about the antecedents?
No antecedent.
Where have you said that? Where have you said that? In the
No, I
petition?
have not written, but I got instruction that there is no criminal antecedent. Lordship, verification of antecedent.
Petition relating allegation against the petitioner shown. Petitioners have filed the injury report. Injury report, which is annexed 2 to the petition, which indicates that the injured Gopalakant, what is his name?
Gopalakant.
Has sustained 2 injuries. One is contusion and another is lacerated wound. And both the injuries are simple in nature. Both the petitioners have not disclosed regarding their antecedents. Therefore, the arresting officers are released subject to verification of their antecedents. Yes.
Obliged.
57.
May please, Your Lord. Non-bailable offences 331, 305, 74 and 351 of BNS, Your Lordship. Allegation is that, a very peculiar allegation, my lord. It is alleged that ଆମେ ଶୋଇଥିବା 2 ଝିଅ ସହ ଶୋଇଥିଲୁ ଠିକ ଏଇ ସମୟରେ କୈଳାସ ମୁଗଲର ପ୍ରେଜେଣ୍ଟ ପିଟିସନର ଆମ ଛାତ ଘର କବାଟ ଭାଙ୍ଗି ଘରେ ପଶି ମୋତେ ଧର୍ଷଣ କରିବା ଉଦ୍ଦେଶ୍ୟରେ କହିବାରୁ ମୁଁ ଖୁବ ଜୋରରେ ପାଟି କଲି ମୋର ପାଟି ଶୁଣି 2 ଝିଅ ହଠାତ୍ ଉଠି ପଡ଼ିଲେ ସଙ୍ଗେ ସଙ୍ଗେ ମୁଁ ପିନ୍ଧିଥିବା 1 ଭରି ସୁନା ଚେନ 1 ହଳ ସୁନା ଝର ଛିଡେଇ ନେଲେ ମୁଁ ତା ହାତରୁ ଜୋର ଜବରଦସ୍ତ ଧରି ପକେଇବାରୁ ସେ ଧରିଥିବା ମୋବାଇଲ ଖସି ପଡ଼ିଲା ଓ ସେଇ ମୋବାଇଲଟିକୁ ମୁଁ ଛଡାଇ ରଖିଛି. This is the allegation. And
There is a theft of both cell millers.
And antecedents?
Antecedents.
You tell, have you said anywhere?
No, my lord, I have not stated, my lord.
Then subject to verification.
Subject to subject.
But antecedent not similar, my lord. Antecedent.
That petition, the petitioner is not mentioned regarding the criminal report, not regarding involvement in other criminal. In any case.
The antecedent,
Also,
there is an antecedent.
Is there?
see.
That's the broad.
Antecedent.
Habitual.
Not similar, probably, my lord.
The state council has points out A state constitution on the basis of breaking instruction is pointed out that the petitioner is involved in three more cases. And particular of those cases has also been placed on the cover. Photocopy you give it, huh? Placed on the cover. In view of all the evidence that in view of the criminal individuals, that's what the prediction and inclined to clarification on NDPS admit to the petition on the individual, however, the open for the petitioner to move to the current court after secondary for grant appeal same day considered. Yes.
59.
That all the allegation against one Amir Khan, that he has already arrested my lord. And that as per injury report, that 5 abrasion injury is a lot simple, my lord.
So the injury.
That is,
You have the injury report.
Yes.
What is your name? Name is Mohammed Khan. What are the allegations? 1, 2, 3, 4, 5 injuries. Aberration. Only aberrations. Yes. How many injuries are there? Basant Gupta.
5 injuries are there against that. Against one Amir Khan, my lord, he has already arrested.
Sujata Mudli and the Basant Gupta.
Basant Gupta.
How many injuries are there?
One.
No. Then what? Who is Sujata Mudli?
One.
You are giving Basant Gupta.
That Basant Gupta is that in front.
Two injured. Yes. How many people got injured? Who came? Thomas the road. Assaulted him by showing knife, gun, drugged him.
If
Gun cut.
Chane, Basant Gupta in front की कुछ होते नहीं बड़े.
See, this is also there. Not sure about anything.
Statement.
Sir, same day.
No antecedent. मुखली सांगेर थेली. Amir Khan आले against Amir Khan.
You have used gun.
No, my lord, Amir Khan. That Amir Khan.
Whatever. Gun.
Against Amir Khan, my lord. मुखली सांगेर थेली Amir Khan against the allegation he was already arrested, my lord.
Assaulted him by showing his.
Against Amir Khan, my lord.
No.
There is there.
See the allegation. Forcibly took him and Thomas Hospital. He said Abdul Amir Khan.
My lord, Amir Khan, my lord. Against Amir Khan.
Fazal Khan. Who are you?
Both are there.
Both of them are there.
Both are there. ये सांगेर थेला Amir Khan against the allegation assault and gun. That is against Amir.
There are 2 injured. On the same day. Same day by both the courts. Yes. By both the courts, same day. Yes. 60.
On behalf of Mr. Dugdar Mahapatra, my lord, offense under section 318 clause 4 of BNSF, my lord, allegation that, my lord, the informant gave the money rupees of 1,70,000 for him giving job, my lord. And the presentation already returned the money, my lord, 20,000 rupees, my lord. That is the allegation, my lord.
You taken money how much?
1,70,000, my
For
lord.
giving the job.
Job.
They have not given job. So.
Man, he has all.
How many cases are there?
One. Is it
He has taken money from how many people?
one?
No, that's antecedent.
Antecedent, my lord, no antecedent, my lord.
It's written.
Yes.
Show me.
No idea.
No antecedent. What is his name?
Lakshman
Pandey. Nothing else.
Nothing.
It is no. Instruction the council of the state service that the petitioner will no criminal evidence regarding it to nature of it. That's it. Yes.
61.
61 no affair.
has not been registered as per my instruction, but the pendency of the check bounce case, he has threatened to lose the affair. On the same matter, the check bounce case is pending, my lord, before the London Restigium Bhubaneswar.
The response for the petitioner at the outset suffice that there is no FIR or complaint as yet registered against the petitioner. However, he apprehends arrest because one of the checks issued by him got degenerate and for which a proceeding under section 138 NI has been initiated. The complainant has been threatening to implicate in some other case pertaining to the same transaction. Therefore, he has approached this court. 1 month notice. Yes.
62 pass over.
Pass over.
63
The alleged offense under section 3032, 111(4), and 35 of the BNS, along with 11(1) ADE of the prevention of cruelty.
Yes.
City has not come.
What are the allegations?
Cattle,
Two antecedents.
Allegations.
cattle transportations and
Transportation of
and 11(1)A of the protection.
The statement of the driver, the name of the person. It's not under more than 18 persons.
All for CD, please the matter on 15. No course question till then. Yes, next.
64
Alleged offense under section 3032 of BNS at corresponding office 379. 379. One.
Antecedents?
Antecedent, my lord, I have don't have the information, my lord. One stolen bike of the informant recovered from an Ashok Naik. Motorcycle. And on interrogation of Ashok Naik, he stated that he had purchased the bike from the present petition.
Principal accused is Ashok Naik.
That's antecedent.
Ashok Naik. Ashok Naik is the person from whom the vehicles were recovered.
But he has purchased from that petitions.
What is his name?
Dharmananda Naik.
Bottom of the
Verification of Dharmendra Naik. So you have on 2 more cases. Current petition is from
surrender.
The petitioner submits that the vehicle which is alleged to have been stolen has been recovered from one
Ashok Naik.
Ashok Naik. And Ashok Naik, the petitioner, the allegation is the petitioner has purchased those vehicles. The State Council on instruction, by relying upon the written instruction, submit that the petitioner is involved in more similar cases. Two other cases. Two more other cases. Because we had to name the antecedents and they grant to the open for the petitioner to surrender and for the lobbying and the same celebration of the same day. Yes.
Same day?
Same day. And it is open for the petitioner to all the grounds, including the ground of parity, while pressing his application for grant of availability. Yes.
65
Withdraw. Yes, 67. चलो कुछ करो 15 मिनट
66
पास हो गया
57
Allowed in this matter, the POSCO was there.
Citizen POSCO is there, notice. POSCO is not.
68
May I please announce? The petitioner, not who happens to be a bank employee, is in custody since 18 to 2026 for the offence alleged under section 18(2). Charge sheet has been submitted. Their offences are 294, 420, 468, 471.
What have you done?
Allegation is that when he was working as the bank manager, instead of advancing a loan of 30 lakhs as CC, he has done it 60 lakhs, giving an impression to the informant that it is 30 lakhs and he has to repay in 30 equal installments at the rate of 1 lakh. So the allegation is that they repaid the amount 30 installments. When they went to the bank authority said that no, it is 60 lakhs and it has been 84 installments. You have to pay.
You are the manager.
That time it alleged that I was because they are known to each other. And now he left the bank.
You have cheated 2%. One is the complainant as well as the bank.
Plus, here what has happened in the meantime, he approached the ombudsman and the ombudsman has passed the order, reversed the account. So he has got that relief of 30 lakhs. Now he is not at loss.
Well, he has paid. Obviously, he has paid.
Nobody is paid. जो 30 lakhs रखे हैं because he had not availed 60 lakhs CC loan रो. He had availed 30 lakhs, he repaid it. तेणुकरी 30 lakhs टा reverse करने पे ombudsman direction दे जाले.
You verified. Verified. Why don't you pay it and finish it up?
Yes.
In any case, you have taken the money.
No. पैसा नहीं ना. Also again, I'm not. Loan to the tune of 30 lakhs was CC loan of 30 lakhs was advanced.
Yes.
Instead of 30 lakhs, which he had intended to take. 30 lakhs, he had the impression that he has been advanced a CC loan of 30 lakhs. He repaid it within time. When he went to the bank authority said, no, it's not 30 lakhs, it is 60 lakhs. And instead of 33 installments, it is 84 installments. So
You are appearing in this.
My lord, for informant.
What do you say? The ombudsman has passed some order.
No. See, that is the different things. He give the detailed 30 lakhs from my side, which I have paid to him at the time of bank, with the fraud document. पूरा बैंक रो डिटेल करी की देई देला कि आपले किछि दिन पर बैंक मते नोटिस कला त पैसा देइनो.
Yes.
Two things are fraud document.
He has created the job.
Yes, my lord.
Okay. What is the modus operandi? You paid the installment, he didn't deposit it.
Yes, my lord. And he give the false slip and checks. Subsequently, he do one things. He give me undertaking and understanding to us and compel it to me the compromise, and he will be ready to pay 30 lakhs. This is the bank statement which we have after letter back.
That's the I see it. Yes, the installment he intended to pay was paid to you.
But that's
and
he
you
say,
didn't deposit.
again, he says that he has paid in cash, Milord. And
You have issued notice, receipt to that effect.
because 30,000 has been paid, Milord. 30 lakhs has been paid. What he says, 30 lakhs has been paid by me, Milord.
The bank account is now closed.
No. That is being.
And this allegation is after 3 years.
No, my lord, that is wrong. This is the slip which he has given to me.
Sir, this
File an
is
objection.
You oblige, my lord.
File objection. I'll take it up on
Monday.
Monday. Let it be a Monday only. 11th. 11th. Okay. File an objection. Whatever.
Oblige, my lord.
Yes.
69.
Let's hear.
If it's possible, if you want to settle also, you can try.
Once he will give the madam, sorry, extremely sorry. One thing. He made an.
Is there any scope of settlement?
No, that is the totally depend upon him because he is
Mr.
it
Sankar,
totally depend upon him.
Take instruction if it can
That's
be
it. Kindly
settled.
peruse one document I have annexed. I am showing you.
In any case, it is a money transaction only.
No.
In the end of the day, it is money transaction.
Yes.
So
it is about my 30 lakhs.
If you are agreeing to pay, think over.
ଆଗ ଆସୁ 11 କୁ ଆସୁ I will say.
Because lordship ତକ ବି ଦଉଛି ସେ ଡାକି କିନି ଗୋଟେ ଏଗ୍ରିମେଣ୍ଟ ମୋ ସାଙ୍ଗରେ କରେଇଥିଲି ସେ ଏଗ୍ରିମେଣ୍ଟ ର କପିଟା ଟିକେ ପେରୁଜ କରି ଦିଅନ୍ତୁ ଦେଖନ୍ତୁ ଆପଣ
You file 11th and take it. Yes. Next.
Let's hear the there are two cases, Milord. Both are ladies. It is alleged that when those two persons, Milord, who descended from a bus at the Bermuda bus stand, Milord,
Custody
since Milord, 11 to 2026, 21 kilos, two ladies.
Yes. Yes.
21 kg ganja.
Huh?
Ganja 21
Lady,
kg.
lady. Both of them are lady.
Both of them are ladies.
And
And ଯାଉଥିଲେ ସେ କହୁଛନ୍ତି ଯେ ଦି ଜଣ ଯାକ ନେଇକି ଆସିଥିଲେ both belong to different villages, not from the same village.
What is recovered from the Namita? How much?
କାହାଠୁ individual କହୁନାହାନ୍ତି ଦି ଜଣ ଯାଉଥିଲେ ଆମେ ଧରିଲୁ 21 kilos, so both have been forwarded.
Let us see which part.
It's a Lordship also have given the copy of the complaint. It's a by the excise people, my lord.
Read it.
Page 11, my lord.
Hmm.
ଅଦ୍ୟତା 12/2/2026 ସକାଳ ପ୍ରାୟ 6:15 ସମୟରେ ମୋର ବିଭାଗୀୟ କର୍ମଚାରୀମାନଙ୍କ ସହିତ ଅଫିସ ଗାଡି ନମ୍ବର ସଚେନ୍ସରେ ଭରତପୁର ଛକରେ ପେଟ୍ରୋଲିଂ ଡ୍ୟୁଟି କରୁଥିବା ବେଳେ ହଠାତ୍ ଏକ ବିଶ୍ୱସ୍ତ ସୂତ୍ରରୁ ଖବର ପାଇ ଯେ 2 ଜଣ ମହିଳା ଗୋଟିଏ ଧଳା ରଙ୍ଗର ଜରି ବସ୍ତାରେ ଗଞ୍ଜେଇ ରଖି ବରମୁଣ୍ଡା ବସଷ୍ଟାଣ୍ଡ ପାଖରେ ଛିଡା ହୋଇଛନ୍ତି। ଏହି ଖବର ସତ୍ୟତା ହୃଦୟମ କରି ସଙ୍ଗେ ସଙ୍ଗେ ଏହାକୁ NDPS ଆଇନରେ ଧାରା ସଚେନ୍ସ କରି ମୋ ଉପରିସ୍ଥ ଅଫିସର ଡେପୁଟି ସୁପରିଟେଣ୍ଡେଣ୍ଟ ସାର୍ଙ୍କୁ ଫୋନ ଦ୍ୱାରା ଜଣାଇବାରେ ସେ ମୋତେ ଘଟଣାସ୍ଥଳକୁ ଯାଇ ସେହି ମହିଳା 2 ଜଣଙ୍କୁ ବିଧିମତେ ତଲାସ କରିବାକୁ ନିର୍ଦ୍ଦେଶ ଦେଲେ। 2 ଜଣଙ୍କୁ ବିଧିମତେ ତଲାସ କରି ଏହାପରେ ମୋର ଷ୍ଟାଫ ମାନଙ୍କୁ ସାଙ୍ଗରେ ଧରି ବରମୁଣ୍ଡା ବସଷ୍ଟାଣ୍ଡ ଆଡକୁ ଯିବାରେ ବରମୁଣ୍ଡା ବସଷ୍ଟାଣ୍ଡ ପୂର୍ବରୁ ଖବର ମୁତାବକ 2 ଜଣ ମହିଳାଙ୍କୁ ଗୋଟିଏ ଧଳା ରଙ୍ଗର ଜରି ବସ୍ତାରେ ଛିଡା ହୋଇଥିବାର ଦେଖି ମୋର ମହିଳା କର୍ମଚାରୀଙ୍କ ଦ୍ୱାରା ଅଟକାଇ ଘେରି ରହିଲୁ ଏବଂ ସେହି ବସ୍ତା ମଧ୍ୟରୁ ଗଞ୍ଜେଇ ବାସ୍ନା ବାହାରୁଥିବାର ଅନୁଭବ କଲି। ସେହି ମହିଳା 2 ଜଣଙ୍କୁ ଆମ୍ଭମାନଙ୍କର ପରିଚୟ ଦେଇ ସେମାନଙ୍କର ପରିଚୟ ପଚାରିବାରେ ସେମାନେ ନମିତା ସଚେନ୍ସ ଦେଲେ। ସେମାନଙ୍କ ପାଖରେ ଗଞ୍ଜେଇ ଥିବାର ସନ୍ଦେହ ହେଉଥିବାରୁ ସେମାନଙ୍କୁ ମହିଳା କର୍ମଚାରୀଙ୍କ ଦ୍ୱାରା ତଲାସି ନେବାକୁ ଚାହୁଁ ବୋଲି ଜଣାଇ ସେହି ପାଖରେ ଛିଡା ହୋଇ ଦେଖୁଥିବା ଲୋକମାନଙ୍କ ମଧ୍ୟରୁ ଜଣକୁ ସାକ୍ଷୀ ଭାବେ ଡାକି ତାଙ୍କୁ ଆମ୍ଭର ପରିଚୟ ତଥା ଘଟଣା ବିଷୟରେ ବୁଝାଇ ତାଙ୍କର ନାମ ଠିକଣା ଲେଖି ତାଙ୍କ ସାମ୍ନାରେ ମହିଳା 2 ଜଣଙ୍କୁ
Criminal antecedents?
ଲେଡିଜ ଜଣଙ୍କୁ ତ ନାହିଁ ପତା।
Have you said anywhere? File affidavit.
I've not spared specifically in my
File affidavit regarding to
my friend can take also instruction notes because affidavit.
Least on 7. In the meantime, the petitioner to file affidavit, comprehensive affidavit disclosing regarding the criminal antecedents. Yes.
Sir, mo sangare tanku bi instruction semane bi
You
anu.
also get.
Dita gale suvidha.
State council is also to obtain instruction regarding the criminal antecedents. Yes. 70.
25 arms, sir.
Yes.
Was arrested with 53 numbers of talwars and 8 numbers of knuckles. With regard to Gurudwara, sir.
Custody since? Custody since?
Custody since 28/1/26.
Petition belongs to Chhattisgarh, belongs to Chhattisgarh. That is 53 number of long torwal, large number torwal and 8 fighter as recovered from this.
And what about the criminal antecedents?
No one.
File affidavit. Comprehensive affidavit to file disclose. Yes, because interstate arms. It's not.
Lordship is fixing to.
I'll fix it upon 15th. Yes, next.
Yes, no.
15th.
65/49.
It's all right, but you see interstate. You verify and you in the affidavit you have to disclose your permanent address and who will be your local security and all. Everything you disclose. Yes. 71.
Resolution 302. But without going into the merit of the case, my lord, I filed a miss case for interim bail on the ground of further
Verify the interim bail. The father's illness, huh?
Yes.
Mr. Ireland counsel for the petitioner at the outset submits that he would not press the bail application, the regular bail application. However, he moved an application. However, he moved an interim application for grant of interim bail on the ground that his father is terminally ill. He has enclosed a certain medical document along with the application. Let the state copy of the application along with the document has already been supplied to the state council, who shall obtain.
That was there in the.
Who shall obtain instruction by 6th of May. 6th of May. Okay. Yes, next. 72.
Yes, matter, my lord, also.
Issue notice. 73.
No, sir, even for adjournment.
Adjourned, on request adjourned, yes. 74.
So the sections are under 137(2), 65(1), 64(2), 296, 351(2) under BNS and section 6 of POCSO.
POCSO is there.
Yes, sir.
Issue notice.
My lord, just allow me 5 minutes. My lord, POCSO will not be maintained.
But it is there in any case. Notice has to. Yes, next. Next, 75.
May I please your lordship? See, case of possessing disproportionate assets, that is 13(2) relative section.
Custody since?
Custody 8/3/26.
Yes, rejection, what happened?
Rejection order para 1 and 2. 17 दिन संवत्सरे जो rejection है.
Now, what do you want?
No, I just. Your lordship distinct on that. That is said.
No, just, you wanted to highlight, what do you want to? Which part?
One.
Amount.
Regarding RIMS and a percentage of D. That's.
Okay, granted. Allegation is the petition from the applied for bail, applied for bail, which is rejected, is regular bail, regarding the nature of offense, period of custody from age 3/2022, admitted to the bail. The condition that he shall appear before the trial court diligently without fail, and non-appearance before the trial court without any pungent and content and explaining a reason, and deal cancellation of bail. Yes.
This should have assist the IO in course of appeals.
Investigation is not completed.
No.
Achha. Then it was investigation is still going on.
By producing.
It is
cooperate करियो ना ये तो तुम कोई भी active हो.
Petitioner to extend all cooperation to the investigating officer, and then he shall appeal for the investigating officer as and when it is required. Then when it is.
I don't know when required.
You will appear before the court action. That's it. After charge sheet is filed, he shall appear. Yes.
May I say one thing?
Yes.
This is the only request. If the order will be available in course of the day.
All the order will be available. Yes.
76.
Issue is there, notice.
Issue notice.
One more prayer, my lord. Petition is in custody 2022. Short date, your lordship.
22. Okay. 14th, huh? 14th. Yes.
77.
May I please, your lordship? Your lordship, offense under section 20B2B, your lordship. It is under commercial quantity, your lordship. Quantity of 16 kg, 512 gram, your lordship.
Custody since?
Custody since 31/12/25, your lordship.
31/12/25.
31
Rajasthan.
December 25, your lordship.
It's from Rajasthan, so according to some condition may be fixed.
And antecedent?
No, your lordship.
That has not been called for.
Well, you file affidavit. File an affidavit disclosing the criminal antecedent and
one local surety.
permanent address and the address of local surety.
Local.
You file affidavit and release.
Your lordship.
Okay. When? The 8th?
After 10th, your lordship.
Okay, after 10th. Okay, 15th.
Yes, your lordship.
15th.
Oblige, your lordship.
78.
Similar. Nature of implication, my lord, the co-accused confession, my lord.
Sorry?
Nature of implication, my lord, co-accused confession. My lord, case is like this, my lord. Ganja was seized from 2 vehicles, my lord. One of the vehicle, my lord, belongs to the
109 kg,
Maybe.
109. Chhota antecedent.
Nothing has been seized from
antecedent.
He fled away.
Completely, my lord, political motivated case, my lord.
Fixed antecedent, what to do? All political motivated.
My lord, since my lord, he is a locally, my lord,
After vacation.
belongs.
After infringement.
My lord,
I'll reject unnecessary. Why will you wait?
Before vacation, I will file my comprehensive.
Before vacation, you can't get away with the antecedent part.
Yes, I will file my comprehensive affidavit.
Okay, comprehensive affidavit to file and reach 21st. Yes.
79.
79, my lord, on the accusation that the petitioners were helping the informant to opening a bank account, and subsequently, as per the allegation, the accused persons are handing over the said account to the fraudsters for committing online frauds. But in this case,
account खोलिबे तांको नारे पछानबे सेमानको नारे साइबर फ्रॉड केस सब.
in this case, no victims are there. And my lord, till that investigation over, And only Miller the informant alleged that mate 1500 टका देगी mo नारे गोटे account खोली
No, no, you are making so plain and simple, but it is a big racket.
ना big racket की
It's
नहीं
a
बस
big racket and
किछि नहीं है चार्ज शीट रे किछि नहीं
everybody is a victim. You, me and all of us. Everybody is a victim in the end.
हजुर
This has become a man's, you know.
but ଆମର କିଛି role ନାହିଁ ଆମେ ଖାଲି convince the informant to opening a bank account
Custody since
custody since Miller 23/2/2026 2026
antecedents.
antecedent नहीं Miller
Fine. Let him file affidavit. File
No.
comprehensive affidavit to file disclosing antecedents. No. Yes. To be verified by the state council is the matter on 15th. Yes.
tomorrow Miller list
15. Yes.
May I read the covers? And the offense against the petitioner, sir, under section 20B 2IC NDPS. And the 48 kg ganja was seized from the petitioners. And he's in custody, they are in custody since 11/10/2025. 11/10/2025.
25.
My lord.
Antecedent?
No, my lord, there is no accident. I have filed the documents. And the certified copy also available with your document.
Nothing is filed except the rejection order. Nothing is there on record.
No, my lord, on 24.
File an affidavit,
My
comprehensive.
lord, that is certified copies.
No, file comprehensive. Let it come. Comprehensive disclosing the antecedent. Please the matter on 15th. Okay.
There may
Right.
may
Yes.
mention because I could not reach in time due to blockage of road. And I approached the deputy registrar. He told me that it has to be mentioned in this honorable court only.
Which one?
It is a transfer matter, so that 4 times I have filed memo. It has not been listed. Tomorrow, if it can be.
What is
It's a
this?
CRPF matter, choice of posting. One has been given, but I have.
Is it assigned to this court?
Yes, deputy registrar told me that it is to be mentioned in this court and then it can be taken. I went to the.
CRP employees and must be assigned to. What is the urgency, madam?
Because the transfer otherwise, I have filed it most probably 15 days. That CRPF
When
matter
transfer-
and one battalion to another battalion.
That transfer matter, you know, how the court and.
Choice of posting. Another friend has been given 20 years he has served.
Are you imputing malafide?
No, nothing.
Then no question of
No,
interference.
because that is as per the rules. Choice of posting CRPF persons.
what
Those
is the
who are
great-
serving in
What is the great urgency?
Jammu and Kashmir.
What is the great urgency?
Already transfer order has been made so that he has to move. If that will be stopped, then
Monday.
another friend has been given.
Monday.
Tomorrow.
One prayer, that document was filed on 24/4.
It's not there on record.
Last me directed the registry to.
Mr. Mishra and counsel for the petition also submits that he has filed certain document
24/4/20.
on 4/4/2026.
24/4/2026.
Which is not, which has not come on record. They issue to verify and place it on record.
Nice.
I'll come.
Pasur item 1.
My lord, I/3/2025 order. My lord's order has not been complied with and taken
Five,
instruction. 5/5/2025. 5/3/25. Lordship's order, page 57. Instruction. Specific lordship's right.
4 and 5 pillars.
The. Five, three, you said, no?
Not my lord. Page 57.
Well, that order is not uploaded.
Page 60.
Huh?
Lordship's.
Upload. Was earlier order. Okay.
My lord.
Okay, earlier, yes.
Page 60, operative part.
Yes.
Extensively as possible, preferably within a period of 3 months. Specifically, lordship director.
I asked you to file.
And then, in this case, this order has not been communicated to the trial court because neither the petitioner submit the copy of the trial court, the order passed by the trial court, not from the registrars.
But
That may be the reason perhaps that then he may not have seek for extension. And your lordship will find para 3, I have given short note. Para 3, your lordship.
Assembly submitted that
Para 3.
more than 56 adjournments.
From the date of cognizance to charge, 2013 to 19. And the accused present petitioner appeared only on 8/7/2019 by execution of NDPS. And another accused in this case also appeared thereafter.
Lordship.
So, and your lordship will find that thereafter also. The lordship passed the order, thereafter accused persons are.
My lord, arguing my lord in technically, lordship may see, page 26.
Para 5 you said.
Ma'am, even though the trial could not be concluded within the stipulated director by the this, no extension has been sought for by the trial court. The order sheet does not reflect regarding any intimation of that order dated at the from the registry of this Hon'Ble court.
Which order sheet you are referring to?
My lord?
Which order sheet you are referring to?
The order sheet they have filed, trial court order.
Okay.
Order sheet.
And what is the order was communicated of now?
11/12/25.
Let us see. This is part on in the 2566, huh?
Then para 6 and 7 your lordship.
And again, one Nursinha Charana Behera also approached this court. There is some direction here also.
Yes, my lord, that is 2 read petition. That is 6 months. Thereafter, your lordship granted 3 months.
Within 6 months.
ସେଇଥିରେ ରିଟ୍ରେ 6 ମାସ ଦିଆ ହେଲା ସେଥିରେ ସେ ପ୍ରେୟାର କଲେ ଏକ୍ସଟେନସନ ପାଇଁ ସେଥିରେ ବି ହେଲାନି ତାପରେ ହଜୁରଙ୍କ ଅର୍ଡର ହେଲା 3 ମାସ within 3 months extensively କରିକି ଆପଣ ଅର୍ଡର ପାସ୍ କରି that I have read your lordship may see that. Yes. Long pendency of the trial proceeding, I feel it expedient to direct the special judge Reliance Kotak to conclude the trial.
But what is your explanation? You are not appearing before the court, and only
in that respect, I have given that death chart. Lordship may see delay caused by your lordship may page 26 of my death chart.
Death chart.
On behalf of the petitioner, my lord, 180 days delay. Your lordship may see that page 26. Elaborately, I have given
26 of
my death chart.
In the first item.
My lord?
In the first item you are talking.
Yes, my lord.
Where is the date chart?
Delay.
Like one.
From date of affair to final form, thereafter charge, then cognizance, then thereafter charge. Put a witness.
From cognizance is taken on 2013.
13 million. Thereafter charge 2024.
If you don't appear.
Only basing on
what happened in between 13 to 24? 13 to 24 you didn't appear. Therefore,
only stay period.
When NDPS was issued against him?
Not against him. You see the page 86 of the note, the counter filed by the dead chart, everything filed, document filed by the, that is the order sheet.
Entire order sheet I have filed.
86.
86.
Yes.
Your lordship got it. And order sheet.
Yes.
86, that is cognizance was taken.
1 minute.
Order sheet 86.
Let us see 2030. Cognizance taken is on 30th.
30/10/2013.
Okay, cognizance is taken.
Cognizance taken.
Yes.
Summon issued. Then your lordship next page. 28/11 accused absent. 18/1 accused absent. 18/2 accused absent. 19/3 till your lordship come to page 56 adjournments. In different fit test and accused are absent. Thereafter NBW was executed. Then your lordship kindly come to straightway come to page 119. of the order sheet. Your Lordship, latter order 15/7/2019. On that date, accused Ashutosh Bera surrender before this court.
When NBW was issued?
NBW was issued prior to that.
Show me that day.
That is in death check I have reflected, my lord. Page 26.
No, let us see the proceeding.
Delay, your lordship may see. Delay to stay by the honorable court for 6 months.
Page, your lordship, page 115.
Order se order sheet upon take mu jo that death check haju dechi.
Date order sheet ta dekhundu. 16/4/2019. Order. Page 115. Accused persons are absent on call. No steps taken on behalf of the accused. The case is posted today for consideration, sir. Neither the accused persons appeared nor any steps are taken. This is a case of the year 1999. Hence, issue NBW against the accused persons. Thereafter, the accused was surrendered on 15/7/2019. Those are the petitioner in this case. Thereafter also, your lordship will find next page 112. Number gote accused appear करछन. 112 रे 14/8/2019. Your lordship.
Yes.
Their accused persons are present. 80 कोटी present रहिले and other accused persons are absent. All the accused persons in the absence of accused persons, charge cannot be framed. Only after your lordship, thereafter accused persons are absent, then only charge was framed thereafter. Charge was framed on 22/2/2024. That is page 154. By 22/2024, there the charge was framed. Thereafter, in the meantime, 2 witnesses have been examined, and your lordship kindly will find that they have also filed discharge application. That was filed challenging discharge.
I have seen it.
Yes, my lord, he is saying that 2 witnesses have been examined. Your lordship may see page 40.
But the delay is completely attributable to you.
No, my lord. Your lordship, I have given entire
the charge. See, the proceeding you have filed. Read the proceeding.
My lord, I am coming to the page.
You have never appeared till 2013
my lord, that is
onwards.
180 days delay. That is 180 days delay on the lapses on the part of
2013 to 2019 you have not appeared.
my lord,
And thereafter NBW was issued, executed, thereafter you came and appeared, and thereafter you kept on moving application under 317 and 305 repeatedly.
317 is allowed.
So charge sheet will be framed.
We are ready for court is not. My lord, now list of witnesses they have not given. Then देखो तो last occasion they said that the court has approached this honorable court for extension of time. Now they are saying no extension was.
That is
main issue.
point.
My lord has pointed out that issue.
I will ask the concerned court to give a report. Because see, but you can't take advantage of your own wrong.
I am not saying, my lord, in coordinated bank, while my lord passing for quashing of this proceeding, when lordship order came to the knowledge of the honorable court, then it was referred to your lordship's way. Lordship may see that.
That's right, but the
My lordship cannot deny, my lord.
But the proceeding, see, your only point is.
And referring your lordship.
Your only point is.
My lord.
The delay in the conclusion.
And this is a fact case. Final report submitted.
That's right. Yes, the final report is submitted.
But not on
thereafter, the cognizance was taken. Thereafter, the things are moving.
By virtue of our petition,
but you could successfully, all of you could successfully avoid the court for a very long time. And this is very sudden on the system.
No, my lord, we are cooperating.
Come from the proceeding.
From petition number 1.
Read the proceeding then.
Yes, my lord, I am coming to the my lord fact of the case. Your lordship may see.
No, read the proceeding. Your delay ground. Let us.
Delay ground, your lordship. I have given the entire date. date chart reflecting the delay.
Date charts are 2013
मतलब basing on the
2013 पर 2019 लिखुଛନ୍ତି ତା ଭିତରେ କଣ କରୁଛନ୍ତି ଆପଣ ଦେଖନ୍ତୁ
ଦେଇଛି ମାନେ ପୁରାଟା ଦେଇଛି ଅଜୁ
proceeding ତ ଅଛି why should you go date chart see the proceeding
proceeding I have supplied mail
yes, fairly you have done it fairly you have done it but see the proceeding how many days you appeared within this 20 years
through council we have appeared that
how
if
chart
that
will you
point my lord is raising I will come with that by giving details I will have to go through it.
I'll ask for a report.
Yes, sir.
What is that? What is that order you said? My order was that 16.
Order dated 5/3/2025.
That is a phase.
That is CRLMC number 25. I will also pay para 4 of the
No.
5325 my lord page 57
57
57 page running page order time is 5325 my lord's order
57. No, which one? 2563.
Yes, ma'am.
2566 of 2020.
2566
Which annexure?
annexure my lord
2566.
annexure 12 series
12 series.
my lord 49 to 57 other two did petition orders and then
The advancing and counsel for the petitioner drawing the attention of this court to the annexure 12 series pointed out that despite repeated direction of this court, the trial court without taking extension of time as the trial court has failed to conclude the trial as per the direction and even has not taken extension. The holding bench of this court by the order dated 5/4/2023 in WPC number 7657 of 2023. And I directed the trial court to conclude the trial within a period of 6 months. Subsequently, thereto,
then 1923
another petition was filed by the petitioner by the co-petitioner.
9
By the co-petitioner being WPC number 32648 of 2023. In the state petition as well, the coordinate bench by the order dated 9/10/2023 directed the trial court to conclude the trial
within
6 months. 6 months. Subsequent to 6 months. Thereafter, this court, while disposing of the CRLMC number 2566 of 2024, by the order dated 5/3/2025, being directed the trial court to conclude the trial within a period of 3 months. Within a period of 3 months. Of course, next one. In the last date of hearing, a specific question was put to the counsel for the vigilance as to why the trial did not be concluded despite repeated directions of this court. Persons thereto to the respondent vigilance department has filed an affidavit today. We will take note of that. As per the affidavit, as per the para 5 of the affidavit, it is 5 of the affidavit, the order of this court dated 5/3/2025 in CRLMC number 2566 of 2024, since has not been communicated to the trial court. Therefore, neither the extension of time has been sought, now the trial could be concluded. At the same time, the affidavit also reveals that now the trial in a trial of the case has already commenced. Two witnesses.
Two witnesses has been examined and accused persons are also absent. NBW has been issued.
Two witnesses have already been examined. At the same time, Mr.
On 1/11/2025,
during the
Para 7, no?
course of trial, the co-equal persons, few of the co-equal persons have also did not appear as a result of which NBW has been issued. Mr. Manana, by taking me to the proceeding of the court below, submits that the delay in disposal of the trial is only attributable to the accused persons. It is that is it. Since this court repeatedly has issued directions to the trial court to conclude the trial within the stipulated time frame, it is obligatory on the part of the trial court to comply the order in the event there is any difficulty in complying with the order. It is further the obligation of the trial court to seek extension of time. It appears the trial court has failed to comply the direction of this court, and also not move any not sought for extension of time for concluding trial. Let a report be sought for RAC director to seek a report from the trial court on the condition and leave the matter on 18th October. May 18th October.
18 May.
Your lordship mainly see the orders page 114 of the order sheet. There extension was sought for.
The other one.
Other case.
Let us see.
Order sheet is a question. Can you be extension magi because I think what why because that has perhaps it has not been brought to the notice of the.
I'll give that.
But in para 5 you have said that it's not communicated. So for that order.
I even petition.
The communication we can file it.
Let's say
But affidavit copy
Let us yes. And even today the appeal persons are not going.
Lord, in the manner in which NBW issued, your lordship may see that. I'm just explaining that.
Accused persons were there or not?
He's heaven.
Aditya.
Yes. That petition they issue. I am the counsel in the court below, my lord. Others allowed NBW issued against that Aditya. They are not maintaining properly, my lord.
The NBW is issued against a dead person.
Dead person. I am appealing 317 was allowed. How NBW issue?
Why have you moved 317? Then how why should you blame? You move application. Representing a dead person. And 317 is rejected. And NWG should what? How can you blame?
The hide and seek play.
अपना client भी सर जानना थी कोर्ट जानी yes
केस किछि नाही खाली
equity लगा जल्दी कर देला equity that's the
जल्दी सर हजूर भी लास्ट ओकेजन से कहते 3 मास पर यदि न होला एठी पास कर
I am worried if he has not asked for extension. What is the procedure? Whether an order is passed, it should have been communicated to the trial court. Why it is not done?
We have communicated. We have that receipt, but let us see. Yes, we'll see that.
If the report comes, then we'll see. Yes. Yes. Item 3. Yes. The interest of justice is the matter of summary case. Yes. Summary. Yes. 62. Number 62.
Yes. 109 along with other offences, my lord. This is the certified copy injury report. Palm re gote injury that is simple in nature.
What have you used?
Certified copy.
Cut injury.
Simple in nature.
Allegation is the yes. Assaulted by sword on his head. Sorry?
Allegation assaulted to his head, informant in the injured, and that was in the palm.
By means of sword on the head.
That is simple in nature. Hathare gote palm is
sword blow.
On
the head.
Head ring injury nai.
Then he might have shown the hand.
Out of property dispute occurrence was taken place. Antecedent, no antecedent. Subject to very I have stated in my petition, my
where have you seen?
Your lordship pass on my petition.
if you have an injury report, why don't you file it?
সেটা পছরে আজ্ঞা পাইছি লর্ডশিপ পেজ 3 para 4 that submitted that the petition is a very innocent person of the above said locality having no criminal background.
Subject to verification. Subject to Paragraph 4 of the petition, petitioner has made a specific averment that he has no criminal antecedent. The certified copy of the injury report is shown to the court during the course of hearing, which indicates that the injured, what is the name of the injured? The injured, he is the informant, huh? Same, injured informant, Lawrence. Yeah, Lakshman, yeah, what is it? Fine. Lakshman Swine, huh? Lakshman Swine has sustained a cut injury in the palm, which appears to be simple in nature. Simple in nature. Regarding the arresting official will subject to verification of the criminal antecedents. If any. Yes, next. Yes.
66 may please your lord. Here in this case, my lord, who accused already granted bail as para page 13 your lordship kindly. Page 13 para 5.
Page 13
para 5.
What is your name?
After having considered the rival submission upon perusal of the record, there appears allegation against the petition for abducting and committing murder of the deceased, but the trial court is yet to be concluded even after 2.5 years of the custody matter 14/12/23.
You are Uttama?
Yes, Uttam and
Yes, what are the
Babula.
material?
There is the 4%, the material is there, my lord. Yes.
Against Uttam?
Same allegation against all, my lord. Co-accused considered, my lord, by the honorable court granted bail to Sanjay Raut alias Brahmar Pandi, Sangram Kesari Parida, 3 co-accused person. Page 13 para 5 your lordship.
Yes, yes.
My lord, there are eyewitnesses there and the that my lordship has
Very good eyewitness.
yes, my lord. Satyapatra.
Satyapatra, he has not turning. That's why consider, my lord, this honorable court granted bail. Para 5.
No, let us see, let us see. Yes.
There are out of 14, there are the 14 witnesses have been examined, but those are examined, they are not a vital witnesses. There are vital witnesses, there are Bhagavan Pani.
Read 161
Yes,
statement of eyewitness.
yes, I read it, my lord.
What is the role of Uttam Biswal?
Yes, my lord. Satyapatra, my lord.
Relevant party.
Yes, my lord. 12:45 ଗୋଟେ ଘଣ୍ଟା ମଧ୍ୟରେ ନିଜ ଗ୍ରାଉଣ୍ଡ ଫେରିବା ବାଟରେ କୋଦଳା ଛାଞ୍ଚା
You have to prepare a list with Uttam Biswal, Babula Gowda and Litu Nayak.
my lord.
ଏମାନଙ୍କ ବିଷୟରେ Litu Nayak, Bikram Parida.
ଲିଟୁ ନାୟକ
କାହାର
ବିକ୍ରମ
against
ପରିଡ଼ା
କଣ ଅଛି କୁହନ୍ତୁ?
yes my lord.
Prepare and
is already similar footing.
yes, fifth, huh? Fifth. No, make it sixth.
Order I have annexed, my lord. That should to be verified.
You verify, yeah, verify. If they are similar footing, they will, I'll have to grant them bail. What is the option left?
Since
Verify
last
and-
2.5 years, they are not turning, my lord. He having that witness having 10 cases. Considering that, my lord, this honorable court granted.
Maybe, but what is the role attributed to these people, five
Yes,
people? Let us see, understand. Yes, next.
Uttam has 3 antecedents. I will prepare all this.
Antecedent and everything you have to tell me. On sixth, huh?
ଆଜ୍ଞା ଯୋଉମାନେ ଯାଇଛନ୍ତି ତାଙ୍କ ନାଁରେ 10-12ଟା ଲେଖାଏଁ କେସ୍
81. Please, my lords, 6.6 grams of brown sugar, my lords.
Custody?
Custody since 17 to 2026, my lords. In the meanwhile, charge has already been framed, my lords.
On
24/4/26, my lords.
24/4/26.
Yes.
Antecedent?
2 antecedents, my lords. These are the
ଚାରିଟା ଆଣ୍ଟିସିଡେଣ୍ଟ ଅଛି ବଟ୍ ଏଇଟା ନନ୍ କମର୍ସିଆଲ କ୍ୱାଣ୍ଟିଟି ଯେମିତି
filed.
ଫ୍ୟୁଚର
What about the other case?
My lords, all the cases I have filed.
there are four
Release on bail.
Yes, my lords.
You are all NDPS cases.
My lords, the NDPS case ଅଛି ଆଉ ଗୋଟେ normal. Two similar nature.
Petitioner is accused also. He has filed a comprehensive affidavit disclosing that he is involved in 3 more cases. In all the 3 cases, he is already in bail. As per the allegation, how much is recovered?
6.6 grams of brown sugar.
6.6 gram of brown sugar is recovered, and he is in custody since 17 to 2026. After charge sheet in the present case has already been filed, and charge has been framed on 24/4/2026 regarding the quantity of contraband and period of custody granted. Yes, taken note of. Yes.
82.
Less than commercial point. If
Petitioner earlier approached this honorable court and that petition has been withdrawn.
NDPS in the interest of
Justice
justice
to
is
page
divided
46.
after vacation. Yes, sir.
83.
21B of NDPS Act, my lord, 130 gram of brown sugar recovered from the present petitioner and custody since 14/1 to 26. And charge have been framed in the meantime, my lord.
Huh?
Not.
Case, call for case.
Charge have been framed, my lord, this.
Call for case, leave the matter on the case. Yes, next.
84.
My lord, date
15.
15.
Yes,
84.
May I please, Lord? This case, my lord, cyber crime offense is my lord, and the offense, my lord, is 112(2), new offense, my lord. That is, my lord, whoever being a member of a group or a gang, either a single or jointly committing any act of theft, snatching, cheating, etc., my lord. And other offenses, my lord, 370 that 411 receiving of a stolen property, my lord. And 413 also habitually dealing with such property. And 120B and 114, my lord, assisting the concealment of stolen property. These are the allegations, my lord. But in fact, my lord, the sovereignty of police is the informant in this case. He lodged the information stating therein that police got information that some cyber criminals are active day by day, for which the
how many
police-
cases are there?
Against don't know, my lord. This case present only case, my lord.
File affidavit.
Both are brothers, my lord.
Because it's organized crime.
The amount, my lord, seized from the account of the petition, 2 brothers, my lord, 7 lakhs some odds, my lord. That is available in their passbook, my lord. I'll file after.
Short date, disclosing the incidents. Yes.
85.
May I please say? Offense under 20B to C and section 29 of the NDPS Act.
Yes.
The alleged recovery of ganja is 285 grams, 285 kg,
Huh?
285 kg from a
285.
vehicle.
Okay.
The petitioner is in custody since 12/10/2024, and the charge sheet has already been submitted.
Okay.
Fact of the case is that the petitioner was on the vehicle and the driver was driving on the way. The police officer details and recovered.
Let the case diary be on 250. Call for case diary. Is the matter of revocation. Yes, next.
86.
May I please? 20B and 20IIC, my lord. 41 kg ganja, my lord. Recovered from the auto rickshaw. Petitioner while the petitioner driving the auto.
Call for the case diary. Leave the matter on earlier matter 16th.
Case diary CIG, lordship.
Case diary. What was it? Yes.
41 kg, lordship.
Yes. Yes.
Admittedly, petitioner auto driver, my lord.
That's
While he carrying another person who was sitting in the auto, my lord, auto rickshaw. Police reliably learned that they are carrying ganja. Police stopped the auto rickshaw. Thereafter, the other person who was carrying ganja, he fled away from the state. 2 bags of ganja recovered from the one bag is 21 kg, another bag is 20 kg, my lord. And petitioner confesses guilty. Confesses guilty that they are carrying ganja in the vehicle, my lord.
Auto driver and his possession of that ganja, my lord. 41 kg.
Another person fled away, my lord. That
And
person. Answer next.
Is the
file affidavit. And file affidavit. The other matter I fixed on.
Or say 15.
15.
So George short dated.
18.
18.
Yes, next.
87.
87 my lord 7 kg 700 gram ganja. 7 kg.
7 kg.
7 kg 700.
Antecedent?
No antecedent, your lordship replay.
Subject
Yes, my lord, subject to verification.
Custody since?
25/2/2026.
25/2/26.
My lords.
7 kilo, subject to verification. Yes.
Obligation.
88.
Here, my lords, the allegation is under section 69.
Yes.
May I proceed? Here, my lords, the allegation is under section 69 of BNS. That is newly added, my lords, sexual intercourse, false promisor. Here, the petitioner is in custody since 18th of January 2026. And in the meantime, my lord, charge sheet has been filed, the cognizance has been taken, and case has been committed to the learned sessions judge. Being a session. That exact date I do not have, as per the status showing in the internet website of the learned court below.
What are the allegations?
Allegation which last 7 years, from last 7 years, both the informant and the petitioner were in a relationship. And during the course of relationship, they have spent.
Yes, what do you say? There has not come with, but there is an allegation of my lords. They were in relationship. What is the age of the
32, my lords. Informant 32, petitioner 33.
34, and the informant is 32. 32.
Not sure.
32, 34. Yes, 34 is the petitioner and 32 is so you see. And the para for the injury text granted subject to verification. Yes. Allowed. Yes, next. 89.
51
kg ganja.
51 kg ganja recovered from the backside of the house of the petitioner. And earlier there was a direction.
Cadre is there, Miller. 51 kg ganja Miller's backside of the house. When raiding party was raid Miller's, he has fled away. And some of the persons along with the raiding party had identified that person is the petitioner. That is the allegation Miller's. And all the provisions has been complied with. Yes.
Earlier, Honorable Court.
There is no conscious petition. Conscious, he has fled away.
Is from the backside alleging that this petitioner fled away from the
antecedent?
Antecedent, no antecedent. Earlier, there is a direction to move this Honorable Court after examination of some material witnesses. Trial has been commenced, This is the evidence of the witnesses. Witnesses have been examined. Some of the witnesses have been examined.
No antecedent.
No antecedent.
What have they said? What have they said?
Seizure witnesses,
Seizure witnesses.
Some of the witnesses.
Found that the accused is from the backward yard of the house.
Back side of the house. No conscious possession.
How many witnesses remained?
Total witnesses at least is of 15 witnesses.
How many of them are examined? Get the status of the trial.
Yes. Some of the
least it on 6th. The state council to obtain status of the trial. It appears he is entitled to pay. And criminal antecedent area. Yes. Next. 90. Yes.
252 grams of brown sugar, my lord. The present petition is
200?
young male custody 252, my lord. See, jury for logi 252 grams.
252 grams.
More than 2 grams of commercial quantity. Now custody is since 21 on to 26, my lord. 27 1 to 26, my lord.
Yes.
Not a young man, not proper 42 and 50 NDPS Act, not maintaining the proper procedure, my lord. CJ, no antecedent, nothing else, my lord. First time.
It seized from his pocket.
Yes, my lord. Se caution says that na magistrate को जाने चाहिए ना किसी information
चाहिए. Comprehensive affidavit to file is the matter on 18. Yes. 91.
Which date, madam?
18th, file completion, yes.
My lord,
Ma'am, please, sir.
the first one is mine. Your lordship, kindly see page 12. There is two petitioners. My brother is one. I am for one. 3 kg 960 gram from me, and 16 kg 130 from him. Total 20 kg 80 gram for this. And I am my examination is going on, my lord. But my you will start from
20 kg of
80 ग्राम कर देइजंती बढ़े की मो कदर 3 केजी कदर 16 केजी जाने को हैरान करे तुम करते
yes.
Yes, ma'am. My lord, below commercial quantities, seized from 16 kg,
I told me that from you 3 kg. Where it is?
page 12 they fair page 12
Yes.
ते तो लिखि जंती चंदन बेहरा पकर 16 केजी 130 ग्राम माय ब्रदर इज अपियरिंग मो कदर 3 केजी 960 ग्राम राजीव लोचन
3 kg 960 gram. First petition. What is his name?
ताना चंदन बेहरा
नहीं, राजीव
राजीव लोचन बेहरा
3 kilo 3 kilo
3 kilo 960
and the other accused is
other
Chandan
16
Behra.
kg 130
Chandan Behraru 16 kilo also. Mr. Das, when counsel further submits that the petitioner is a student who is going to appear in which examination?
my lord
Bhubaneswar, my lord.
engineering
Engineering student who is going to appear in his semester exam.
I understand math are already started কিন্তু यार चार रो ଅଛି
Sixth semester, fifth semester,
ଆଜ୍ଞା
7th semester examination like going to commence form 29/4/2020 today only.
ଆଜ୍ଞା
Today it started.
started हो गलाଣି ଆଜ୍ଞା ମୋର 5 रो ଅଛି
And commence also and his paper is with that regarding that custody since
custody since my lord
26
26 2
27/2 27/1
26 2 2026
granted both years below. Yes, next.
my lord
92.
Pardon, my lord.
Very please. Yes.
Permitted to withdraw, Lord, sir.
Permitted to withdraw. Yes.
Pardon, my lord.
Hmm.
Pardon, my lord. My lord, serial number 82, my lord.
I mean 92. If you want to mention, wait till this. Yes.
93, my lord. Allegation of opening mule accounts. Opening allegation against the present petitioner is opening of mule accounts and doing some cyber fraud, my lord, of transacting money. But here, my lord, is the principal accused is Gokulananda Baga, who is the main mastermind in this criminal opening some fraud account and transacting money, my lord.
What are the allegations against you? Tell me.
Against me is that
You have not filed the FIR. Nothing is there.
Yes, FIR copy.
There is nothing.
CD may be
Call
called.
for CD lease the matter on 21st. Yes. 94.
My lord, the petitioner is a lady, my lord. Out of one transaction, my lord, 3 FIRs have been lodged against the present petitioner, my lord. What happened in this case? The petitioner had availed a mudra loan.
Three FIRs against you.
Yes, my lord.
Out of the same incident.
My lord.
What about
One
the
transaction,
other,
my lord.
what about the other FIRs? What happened?
Another bail application number 3161 is pending, my lord.
And
it does not come, and another is yet to be filed. Another case yet to be filed, my lord.
Along with least this matter along with the
BLA case number 3161.
3161 2026 on 8th. Meanwhile, you filed the other one also.
Mine.
Take it. All the three with you. Yes, next.
95. 21 of NDPS Act, my lord. 360 gram of ganja, my lord. Arrested on 17 2026. 360, my lord.
360 kg.
Gram.
Ganja?
Yes. No, fair brown sugar, my lord. Brown conscious. You woman, my lord.
File affidavit 21st. Comprehensive affidavit, yes.
Which date? My lord.
20?
My lord.
25.
Yes.
96.
Yes. My lord. Your Honor, 376 is there, my lord. And custody since 24/7/2022.
24?
7/2022, my lord. Initially, my lord, FIR was registered for an attempt to commit rape. Thereafter, it was charge sheet was filed for the offence under 376. My lord, the statement of the, my lord, victim was very clear in the FIR.
So, show me this. What is the stage?
Lord, stage last witness was examined on 5/8/2025.
Victim has already been examined?
Victim
Show
examined.
me here evidence. Why have you not filed those evidence? Nothing is there. The counsel for the petitioner submits that in the meantime, how many witnesses have been examined?
23 witnesses have been examined.
Already, my lord, in this case, accused statement over, only the case posted for argument.
Then why should I?
What am I lord?
At the outset, Mr. Naik bring to the notice of this court that in this present case, all the prosecution witnesses have already been examined. A statement of the accused under 313 has also been examined. The matter is set for final disposal. At this stage, the petitioner has moved this application. In view of the same, I am not inclined to entertain.
Well, chemical examination report was adopted since 8/5/2025.
But
Not
final stage,
1 year, my
if you
lord.
convicted, obviously, therefore that is the reason.
But if at all he will convicted, he will be put in custody.
97.
My lord, the petitioner is 24-year-old boy, my lord. He's a student, my lord. Your allegation is under section 21C and 29 of NDPS Act. An amount of 1 kg 50 gram has been seized from brown sugar.
Brown sugar.
After here, my lord, out of 12 charge sheet witnesses. my lord.
Yes. 98.
My lord, sir, adjourn this.
After vacation.
May I please note, the petitioner custody since 19/12/25, 23 gram of brown sugar, and final period already submitted on 16/2/26, and charge already on frame on 6/3/26. The petitioner has no criminal antecedent.
What is the recovery?
23 gram.
Custody since?
19/12/25.
And charge has been framed.
Charge already framed.
Framed. No criminal antecedents. No criminal antecedents. Okay. Recovery is 23 gram of brown sugar. Is in custody since 19/12/2025, and it submits that charge has already been framed in the present case. He further submits that petitioner was not subject to verification. Yes, please. 99.
May I please your lordship? In this case, the petitioner is in custody since 37/2025. Allegation against the petitioner is that on 37/2025, while the disease was returning, it is alleged that the petitioner and another person came from his behind and assaulted by means of a bill hook. As a result, he sustained injury and shifted to medical, and after 1 month and 7 days, he died. My humble submission.
Custody since?
30/7/2025. 31/7/2025.
ठीक है.
Millard. In the meanwhile, 6 witnesses.
Eyewitness who are there?
Narendra Malik.
Narendra Malik has been examined.
No, Millard, Narendra Malik has not been examined.
Wait, how many eyewitnesses are?
Narendra and Anita.
Narendra and
Anita Malik.
let them be examined. Right now.
The 15th date has been posted at trial court on 15th for exam.
I just give direction that both the eyewitnesses should be examined preferentially.
18th.
Preferentially. The petitioner is in custody since 31/7/2025 for relief on the charges of against commission of offense under section. And how many witnesses are there?
Out of 13 charge sheeted witnesses, 6 witnesses examined.
Out of 13 charge sheeted witnesses, 6 witnesses have already examined. However, the counsel for the petitioner submits that these 2 eyewitnesses, namely Anita
Namely Anita Malik
And Narendra.
Narendra Malik.
Narendra Modi have not yet been examined. Therefore, although I'm not inclined to take the bail application of the state, our duty is related to the suspect to renew the bail after the eyewitnesses are examined. Eyewitnesses are examined. And it is expected that the trial courts are able to see that the eyewitnesses are preferentially examined over all of those formal witnesses. Yes, next.
Item 100.
Last occasion, your lordship directed the state for getting the report.
I have not received the case diary. In this case, the petitioner is opening account, different person transfer more than one form.
Not the petitioner. Your lordship may see the page number 10. The short note of the inspector.
No, that is the instruction he got. That
On the
FIR you
basis-
won't get anything.
My lord, on the
FIR is only the initial story, but after investigation he got it. 1 crore rupees.
my lord, on the basis of co-accused confessional statement, my lord.
Yes, Mr. Naik, what is that?
Not received the
Let the city come.
Is the corporate case ID? Please the matter on 21st. Yes.
date, my lord.
21st. Yes.
101.
Item 101 millers, all offences are bailable except section 118 1 millers, and which carries a punishment within 3 years, my lords.
You are in custody since?
No anticipated bail application.
What's this anticipated?
Injury report not received, my lord.
Oh, 326.
108. No, 324, my lords. 108 in a corresponding offence, 320, that was earlier bailable. IPC rate available.
You follow Satindra until and all.
Madam.
Satindra until and Adnesh Kumar. You follow that, huh?
Madam.
Guidelines, yes.
102.
My lord, on the last occasion, your lordship called for a report regarding the criminal crime committed by
Have you got it, Mr. Naik?
My lord, I have received the case diary, but petitioner is not named in the FIR. No witness have stated his name. Why is it?
My account number, the FIR disclosed the my account number. Government official committed mistake. I am a farmer. In my account deposited the money of complaint.
But nothing has come. Petitioner is apprehending arrest in connection with the FIR also. Neither in the FIR his name is reflecting, nor after investigation any substantial material is come against him. Hence, the petitioner is entitled to receive it be subject to cooperation. Charge sheet has not been filed. Cooperation and all, and granted. Yes. Okay.
All the offences except 3082 of the BNS, my lord, are bailable, my lord.
308.
My lord.
Yeah. 308. How?
389, 383 of extortion, my lord.
Extortion, my lord, the petitioner claiming himself a leader of the ST and the name of ST demand.
My lord, we
damaged the boundary wall. My lord, that photograph is also attached.
We protested against the informant that believed that the informant had
308 attracts how? What is
Yes,
the
my lord,
sentence?
5 lakhs, my lord. Amuku 5 lakh taka.
No, 308 attracts, what is the sentence?
7 years, my lord.
7 years.
ମାନେ ଆଦିବାସୀଙ୍କ ନେତା କେ ଆଦିବାସୀଙ୍କ ଗୋଟେ
ବୀର ସୁରେନ୍ଦ୍ର ସାଏଙ୍କ ଷ୍ଟାଚୁଟା ଭାଙ୍ଗି ଦେଲା ଆଜ୍ଞା ଇନଫର୍ମାଣ୍ଟ ତାକୁ ବିରୋଧ କରିକି
He submit.
my lord, the informant purchased the land from the land the land from my lord name is Baptist Missionary Society.
Yes.
The accused alleged that inside that land, one statue of Bira Surendra Sai was there, but no such statue, and demanded 5 lakhs. When the informant denied, they have damaged the complete boundary wall.
3 of them. 1, 2, 3.
No, hundreds. 100%, but the petition number 1 is the
Three
leader.
petitioners are there.
3 petitioners are there. Petition number 1 is the leader of that group. Petition number 2 को 35 3 रे notice दिया है ये.
Petitioner 2 and 3.
No, केवल.
What about the
other? They have police do not want to issue that fact.
They are crea-
One and two
one and-
you have not issued
one-
notice, and two you have already issued notice. And what is the difference of the role attributed to them?
My lord, these two, one and two, they are the leader of the आदिवासी मानु मिछ कथा कहि कि ताकू माने प्रवर्ते कि रास्ता रोक करछंती all the creating all this.
Let us see
We are also belonging to Adivasi, my lord.
One Joya Kumar Mirdha is a witness to that demand.
Yes.
Joya Kumar Mirdha is the witness to
read.
ଗତ 2/11/2026 ତାରିଖରେ ଶ୍ୟାମସୁନ୍ଦର ମୁଣ୍ଡା ଅଫିସ କୁ ଆସି 5 ଲକ୍ଷ ଟଙ୍କା ଦେବାକୁ ଡିମାଣ୍ଡ କରୁଥିଲେ।
Shamsundar.
ହଁ ଶ୍ୟାମସୁନ୍ଦର ପିଟିସନ number.
What is Brindavan? I'm granting. Sabita and Brindavan I'm granting, and he has to surrender. The petitioners are accused in connection with their fire notes also songs. At the outset, Mr. Naik submits that insofar as petitioner number 2 is concerned, notice under section 35, so he has already been granted. And he has also read out the statement of what is that statement of from
Statement of
just
Joya Kumar Mirdha. Joy Kumar Mirdha.
Jay Kumar Mirdha and other witnesses, those who are very specifically attributed stated that Shamsundar Munda, the petitioner number 1, has demanded 5 lakhs, and all the allegations that were made against the said witness, said accused. Therefore, I'm not inclined to entertain the indisputed application for petition number 1. However, insofar as petition number 2 and 3 are concerned, their application deserves merit, accordingly, CME 12 hours. In the arresting officer release petition number 2 and 3, and we will have an arrest, and these are cooperative with which we should also. And insofar as petition number 1 is concerned, it is open for him to surrender before the court and as for regular with such a bill of movement, same shall be considered on its merit of the same day by both the courts. By the courts, yes. Yes. So
104.
May I please? On Monday, this matter was there, and I have supplied the copy of the charge sheet to my learned friend.
Case date method, charge sheet submitted.
Madam.
Immoral Traffic Act, no criminal aspect.
And the present petitioner is working.
Immoral trafficking.
Okay.
In all the cases.
Okay.
No, well,
And the petitioner was
only section. What is that?
I am for the item number 3, my lord. I am the proposal.
296 is bailable. 351 2 is bailable. 35 is
3, 4, 5, 6, 8.
yes. So only 3, 4, 5, 6.
That is
Petitioner is working as a
all of them
in the restaurant.
All of them.
Yes, ma'am.
Hotel रे काम करथले माने
କିଛି ନାହିଁ ଭାବରେ they are
No such thing has happened. My lord, if I have gone through the statement of victim,
Investigation.
totally he denied, nothing has been done.
Charge sheet has been filed. You are appealing for whom?
Item number 3, my lord. I am
sub item.
Sub item 3.
You don't want bail.
Hello? Fine.
I don't know after going to the hearing.
You must learn how and you force me to read something else will come out, I'll reject it.
No, ma'am.
I'm made of the mind, stop.
No, ma'am.
In the bail argument, one should be very cautious when to what to say, what not to say. Yes. On 18/4/2026, for Ellis Commission of Office under section 5 to meeting. Also, none of the petitioners have so none of the petitioners have any criminal antecedent. We got been yet to so they are in custody since
18 to 26.
18 to 26. To 26. We are to the nature of obligation and period of custody granted. This shall appeal for the transfer diligently without fail, and non-appearance by the petitioner before the court shall enter in consideration of court. the bail. Yes.
Obvious.
105.
105 also on Monday, my lord, here this, I had supplied the copy of the charge sheet and order of cognizance. And in the meantime, the case has now been committed to the Court of Sessions. Date which for
76, my lord, or victim 164.
the charge sheet submitted 69 of BNS, which is new offense. It were not the corresponding IP purpose. Earlier it was 64.
They married pretending to marry.
It's 28 years.
What is the age of this?
28.
28.
FIR leakage.
What is the age of this boy?
Boy, my lord.
29.
29.
Same age group. Your custody since?
9th February. Charge sheet file, the ST number I am just giving.
Give the charge sheet number.
Petition
Petition rejected from so and so, allegation against the petition so and so. After investigation, charge sheet in the present case has already been filed on. Charge sheet filed on, dated. Date, charge sheet date. Dated so, charge sheet dated so. During the investigation, the
Third of April.
Huh?
3rd of April.
3rd April. During the investigation, the statement of the victim, who is 28 years of age, has been taken, recorded under section 183 of the NSS. Perusal of the statement reveals that the C was in relationship with the petitioner for a longer time, and the petitioner also pretended to get married, and they had registered the and promised to register the marriage. However, subsequently wriggled out. She further stated that believing that the petitioner would be living with her, she had contacted relationship and pregnant, and subsequently the pregnancy was also aborted. Since the relationship between the petitioner and the victim appears to be consensual, inclined to enlarge the petitioner on me. Petition is in custody since 9 February 2020 regarding yet to the nature of intention. Appears not interviewed. Yes.
106.
I have supplied the ST number and court have pending.
106, sir? 106, my lord. Next resolution.
My lords, this is a case where there's a what happens, my lords, during the 2024 elections, my lords, there was a dispute between two political groups, my lords. And one group, my lords, their people were standing at a particular spot, the other group comes and now, my lords, attacks them. Now, once this attack takes place, this group also retaliate in self-defense. And my lords, these swords were distributed by one Kartika Parida. The second petitioner, my lords, I'm not appearing for. I'm appearing for Raju Tare. Were distributed to Pappu Tare, then Pappu Tare, Bablu Tarai and Sukanta Tarai. Sorry, Shivaram Tarai. 3 persons and 1 Raja Tarai, my lords. So, Raja Tarai is, my lords, Shivaram Tarai's nickname is Raja Tarai. Now, this present petitioner's name is Raju Tarai, not Raja Tarai.
Yes.
The role ascribed to him is, my lords, the eyewitnesses have deposed that he has attacked one of the father of the deceased by means of a lathi, and he has instigated other people to my lord, attack these people. That is the evidence against him.
What about the other one?
And the other persons, my lords, I am not concerned. I am not moving way further.
Kartika is concerned, my lord, as per eyewitness statement, including injured come eyewitness, they have stated while the push and pull was there, at that time he came to the spot having three in a bag, 3 swords.
And he distributed.
Not distributed. Assault part is concerned, he has not assaulted to anybody.
Now, in so far as the medical evidence is also concerned,
Custody since
4/6/24.
4/6/24, 9/6. We are from 9/6/24.
9/6/24. And what is the stage of trial?
My lord, kindly have a glance too.
Before my friend starts, my lords, even the doctors, they also say it is a criminal of, it is a case of medical negligence. In as much as when the hand was cut,
died after how many days?
Died after same day, but my lords, they did not prevent loss of blood. He was taken to the DHH. Now, DHH, my lords, I'm reading out that portion from the doctor's evidence. PW1, page 84. Page 76, sorry.
Page 76.
Yes, ma'am. Starts at PW1.
Yes.
The lordship gets it. I was working as assistant professor.
Relevant part.
I was working as assistant professor in the Department of FMT, MKCG, MCH, Barampur. From DHH, my lords, he was taken to Barampur Medical College. Now I am reading out the main portion, my lords. Cross-examination, page 79, your lordships, my kindly.
Yes.
Cross. Cubital fossa is the anterior aspect of the elbow joint. It is a fact that a common man with ordinary prudence will have no knowledge that cubital fossa comprises of vital vessels like brachial artery and vein, which will cause massive bleeding due to cut injury. Thereafter, your lordships may kindly see paragraph 14. It is a fact that if the cut wound of the artery would have been stitched at the first instance at CHC, Khalikot, the blood flow would have stopped. It is a fact that if fluid and blood would have been infused to the injured at CHC, Khalikot, there was chance that he might have survived. So there was a wrong treatment, my lords. My lords, let us say in so far as the present petitioner is concerned, he has not, my lords, I'll read the other evidence also. He has not attacked or anything, my lords. And otherwise also, the entire incident.
Who is eyewitness?
My lords, the eyewitness, if your lordship sees the eyewitness's statement.
3, 8, 9.
3, 8.
And 9.
3, 8 and 9
is
page.
PW3 is.
PW3 is. PW3 is page
90.
90. Abhimanyu Pahan.
Who made a telephone call to someone within 2
my lords, I'm reading from the.
Tarai, Sukan Tarai, Poku Tarai, Balia, Gopi, and Vinay Tarai first arrived at the spot. And then push and pull coupled. At the same moment, Pavlu Tarai and Kartika Purida also arrived at the bike. 10 to 15 others also arrived there. Pavlu Tarai and Kartika brought also. Pavlu Tarai and Raja Tarai. So, Pavlu Tarai is
PW8, my lords,
Here, the
here
Raja Tarai and Raju Tarai are two different persons.
two different persons. And my lords, your lordship.
What is
has
the
seen-
allegation against Raju?
Lord, may I?
1 minute, let me understand. You are appearing
No,
for?
just to save your lordship's time,
You are appearing for whom?
I am for the informant.
Okay.
In
My lord,
fact,
is the allegation against Raju Tarai?
Your lordship, I will say, here everything has been considered. It was considered by your lordship, and your lordship has given a long judgment in that previous petition which my land friend has not committed. He should have.
No.
Yes. Let me complete.
No.
You
You can't interfere with in my submission and say, I have not completed my submission. My lords, when I complete, I have never been unfair to any court, my lords, and I would have said so, my lords, after completing the entire evidence against the petitioner.
He has finished.
My lords, I have to submit, my lords, my entire facts. Thereafter, my lords, I will apprise your lordship as to what has happened.
Very well.
Yes.
My lords,
I saw 2 points for the
Yes.
purpose of bail. One is the eyewitness has not said anything about Raju Tarai as such, and the doctor's evidence. These are
Yes.
the two vital points.
these are the two vital
Yes,
points.
you answer it.
And your lordship, just because my friend is because I have not completed my argument. This has been rejected by this honorable court on 11/8/25, and
That was
paragraph
allowed by
6.
the coordinate bench. This is the application. Your lordship kindly see that order.
But you are also a applicant. It doesn't look like.
Yes, I
You
was
are
an applicant.
That case, 15% allowed to go on bail. In that case, my lord, I have supplied that 4% was refused, and other 3% were allowed to go on bail.
How many accused are there total?
23.
It was a group clash.
Out of 23, how many of them are granted
19 already granted bail.
19.
Yes, sir.
And these 4 persons are there.
Left out.
And
Honorable Court, while
No, I'm just placing paragraph 6 thereafter you all listen to it.
6 of
6 of that particular order, my lords.
yes, paragraph 6, yes.
After having considered, your lordship.
Yes, I'm there. Senior counsel.
Mr. M.K. Mathi, after having considered, paragraph 6. After having considered the rival submissions upon perusal.
You are
of
reading
record-
about this order or the other one?
order passed by Honorable Justice G. Satpathy.
Okay. 6. Yes, read it now.
After having considered the rival submissions upon perusal of record, it is not in dispute that 9 witnesses have already been examined in this case, but the informant and some other eyewitnesses are yet to be examined. But law is well settled that detailed analysis of evidence and meticulous examination of documents on merits should be avoided at the time of consideration of bail applications. It is, however, not in dispute that 15 co-accused persons have already been granted bail by a coordinate bench of this court, but they stand on a different footing with that of some of the present petitioner, inasmuch as there is allegation against the petitioners Papu Tarai, Raja Tarai, Raju Tarai for assaulting deceased and injured persons by lethal weapons allegedly supplied by petitioner Kartika Parida. However, there is allegation against some of the co-accused persons for assaulting the injured and deceased by giving fist and kick blows. In such scenario, especially when the informant and some eyewitnesses are yet to be examined, it would not be proper to grant bail to those petitioners who have allegedly assaulted either the deceased or the injured persons with lethal weapons, or the petitioner who had allegedly supplied the lethal weapons to the co-accused persons at the
Thereafter, what happened? August this order was passed.
This was passed.
In August 25.
My lords?
August
25. Thereafter, development. Thereafter, what is the development?
No
Months have passed.
development.
Witness has already been examined.
After
That was
this.
annexed.
Yes.
Yes.
And whether the eyewitness and the informant has been.
The eyewitnesses have been, the informant has still not been, for reasons best known to the
Eyewitnesses are
prosecution, they have not.
Informant may not be, eyewitness is important. So,
My lord, in this case, my lord, there are 14 eyewitnesses.
These are the eyewitnesses, my lord.
No. Total 14 eyewitnesses, my lord.
all are eyewitness.
No. Total, my lord, total witness 67. Out
14
of
eyewitness.
14 eyewitnesses there. And in the meantime, Abhimanyu Pahan, eyewitness, examined as PW3. Ambika Gowda, examined as PW13. Susuma Parida, examined as PW14. Virat Pahan, PW4. Bapuji Pahan, PW8. Jitendra Pahan, PW9. Other 1, 2, 3, 4, 5, 6. Out of 14 eyewitnesses, 6 examined. Informant not examined. And this unknown court, while rejecting the bail application of the petitioner, clearly stated that still there are some eyewitness and informant are there.
Tell me who are the eyewitnesses?
Yes, my lord, eyewitness, my lord. Those who are yet to be examined, they are Silu Sahu.
Witnesses.
Silu Sahu.
Give me a chart.
My lord.
Give me a chart.
The 5 to 6 witnesses have been examined. PW 13 is an eyewitness who has been examined. PW
14
is an eyewitness who has been examined. Who is directly implicated and clearly implicated is Raju Starai.
Yes, and para 3 of PW3 also.
Yes.
But there are two group class, BGD and
that is
BGD.
prosecution. Everything was considered and some were allowed and some were not. But these are the principal accused persons. And against this principal accused person, at that time there was material. And now there is.
Prepare a chart and give me.
Yes,
now the case has
I have already made a check.
Prepare and give me. I'll put it on Monday.
Eyewitness yet to be examined. Just now I am.
Who are the eyewitnesses yet to be examined? The eyewitnesses, those who have examined, who has said what against whom?
Yes, yes. My lord.
This much chart you prepare.
One case, my lord. There are criminal antecedents against the citizens.
Yes, they have been acquitted. 4 cases. They have been acquitted in the meantime. I have the copy of the.
We'll see that first. We'll prepare. Mr. Naik will prepare. And Tuesday I'll take it. Tuesday. What day? Tuesday will be
past the
5th. 5th I'll take it. Prepare that. Did you follow? How many witnesses, eyewitnesses are yet to be examined? And the witnesses, those who have already been examined, who has attributed what overtake?
Yes.
Against which?
My lord, I have prepared in tabular.
Examined till now.
I'm only
in a tabular format.
Till now, what are the number of witnesses examined? In addition to the witnesses examined, when the bail petition was rejected.
Next.
107, my lord.
Obligation.
107, paper modification of order letter 22/4/2026, my lord. I will open my kind see the your also order, my lord. Last paragraph 5, my lord. My lord, last portion. However, the petition may be directed to surrender before the London trial court on or before substitution move for regular bail in such event.
Yes.
Move before the petition on the trial court.
What do you want?
307. Principal act already religion paper first and second paragraph. First and second paragraph. Same thing.
The petitioner has moved that the application for modification है वो? Modification of the order dated.
Order रहता किसी भूल नहीं modification कौन होगा?
नहीं. First and second.
Why I am entertaining it? After this order is passed, Supreme Court has very specifically said that you can't direct to surrender. I have asked for surrender, so that is the reason I am entertaining.
Simple injury. Again, simple injury. Principal act.
Whatever, I am not. I am just simple. Order dated 22/4/2024/26, whereby while allowing the application, while declining to grant anticipatory bail, certain directions have been made. And the counsel for the petitioner submits that counsel for the petitioner relying upon the judgment of recent judgment of the Honorable Supreme Court. Where is that judgment only slow? I'll give you that judgment. Submits that direction to surrender while rejecting the anticipatory bail application, court ought not to have issued direction for surrendering before the court. Hence, he seeks modification of the regarding head to the aforementioned submission. The order dated 22/4/26 is modified to the extent that it is left open to the petitioner to surrender before the court below and move for regular bail application. If he surrenders and moves such regular bail application, the same shall be considered by the courts below on the same day, on its own merit.
same day parity my lord, same day parity.
Parity वही तो
Parity.
and
For which principal
it
accusation.
is also open for the petitioner to urge the point of ground of parity as the principal accused has is stated to have been enlarged on bail. Okay. Yes, 108.
Deeply. 108 is lordship directed to surrender and parity is there. Lord, what I am praying a first or second or same day, your lordship.
The same court. Where you have the citation of the judgment?
My lord.
You have that citation of the judgment?
No, my lord.
Recent judgment. I'll give you the judgment. Same with you. Seeking modification of the order 23/4/2026. Same to me, same to parity also.
Parity.
110.
18 not back opposite practice madam. It comes from other day madam.
Sorry?
The lordship you should notice, it is not back to not from the private opposition.
109.
110.
110.
Yes. Service not complete.
Yes.
Service is not.
Where service report just.
After vacation.
There is no service report. It seems. AD not backed.
Yes.
4, 5, 6, 7.
Yes, ma'am. Private opposite.
AD has to service service for notice on opposite party number 4, 5, 6 and 7 awaited. Release the matter on 20th.
Interim order to continue.
Okay.
Pardon, my lord.
Yes.
Item number 82. Please kindly request to remove the non-appearance word.
82.
Yes.
Huh?
Item number 82, my lord.
Okay. Appearance on the request. On the request. 82, huh? Definitely.